welcome to Handling Evidence Across Europe, an AIPPI Germany Young Members webinar. My name is Niklas Gajek. I'm a patent litigator at the European law firm Neuer in Munich. I will be co-hosting this webinar today in my function as Young Members representative of AIPPI Germany. For those of you who are not familiar with AIPPI and its Young Member movement, let me quickly summarize how we got here and what it's all about. So for the last couple of years, there was an increased focus at AIPPI on providing young members with opportunities to become more active within AIPPI. And the founding of the Young Members Advisory Committee to the Bureau of AIPPI was one result of this development. And both the YAC and we as young members have been organizing our own events, be it regional or world congresses, or through webinars on an international level ever since. And today marks a very special occasion as we are writing some more AIPPI history. Thanks to the great support and the initiative of the German National Group of AIPPI, we are now witnessing the first webinar organized primarily by the German National Group of AIPPI and its young members. As to the choice of topic, today's webinar will lead us through various aspects of handling evidence across Europe, evidence being a centerpiece of most proceedings, and still we see various differing rules for the collection, admission, and assessment of evidence, and they vary very much depending on which kind of proceedings and jurisdiction we're in. So we are here today to explore some of those differences in handling evidence between, for example, office proceedings, be it at the national level or before the EPO or EU IPO, as well as handling evidence in national court proceedings in many European jurisdictions. And last but not least, also before the UPC. And to provide these insights, we will not only host speakers from AIPPI Germany, but we also have various esteemed speakers from other AIPPI national groups from all over Europe. All of these topics around handling evidence we will address in 4 sessions. Sessions 1 and 2, which will follow shortly, will focus primarily on German, national, trademark and patent office proceedings. Session 3 will give a trilateral review, Austria, Germany, UK on evidence proceedings in civil and common law jurisdictions. And then session 4 will bring together many of these perspectives, and including perspectives from France, Germany, and Italy on evidence proceedings with a particular focus on the UPC. So before we start with the program, I would ask you to welcome with me Dr. Carsten Königer, who is president of the German group of AIPPI and was kind enough to agree to share a few opening remarks and welcome you all officially in the name of AIPPI Germany. Carsten, the stage is yours.
Thank you very much, Niklas. Good morning or good afternoon or good evening, depending on where you are. My name is Carsten Königer. I'm the president of the German group, and I am old, at least older than 36. So what am I doing here? Well, you might think there can be no AIPPI meeting without some wise words from old people. But don't worry. All I want to do here is to tell you that the German leadership indeed is very, very thankful and happy about this initiative by our young members. As you might know, the German group is the biggest group within AIPPI, but we are certainly not the group with the youngest members. However, we hope we are moving in the right directions. We want to make sure that our young members get more out of their membership. We want to give them a voice, not only for themselves, but also for the future of our association. And as a part of these efforts this year, for the first time, we appointed what we call a young member advisor, and this is Niklas Gajek. And Niklas Gajek became very active. We are very happy about this. And we can only say we are thankful, and we wish you a very, very good day of insight and discussion. And we also would like to thank the secretary in Zurich, our people who provide the IT infrastructure to support this event. So thank you very much and have a very good day.
So thank you, Carsten, for your kind words. And yeah, a big thank you also in the name of all speaking today to you, and especially to everyone else who supported this event behind the curtain, which includes many in the German national group and on an international level at the AIPPI. You also already mentioned the General Secretariat. This includes, of course, also the AIPPI events team who are with us today and ensuring that all runs smoothly also on a technical level. So thank you all again, also from my end. And I'm sure that this thank you I can also relay in the name of the speakers. So the last item on my list before heading over to session 1 are a couple of housekeeping rules. First, please note that the webinar will be recorded and that the slides used will be available after the webinar. Second, please be aware that you can use the Q&A function, and we would be very, very happy if you do so and address as many questions as you have to the speakers. And you can submit these anytime. For additional comments beyond questions, please use the chat box, which also is active. And third, we would kindly ask those of you who requested a confirmation of attendance to maintain attendance throughout the webinar. This concerns mostly German Fachanwälte. And last but not least, if you have any technical problems, please send a message via the chat box to AIPPI events, and we will see that we can help you with that. So this finally brings us to session 1, tricks and traps evidence procedures before German national European IP authorities. And I'm happy to introduce to you your moderator for sessions 1 to 3, which is Elisa Hirtreiter. Elisa Hirtreiter is a German attorney at law at boutique firm Stollmeyer and Partner, where she focuses on IP, commercial and contractual law. She advises national and international clients from various industries, both in and out of court, and she will guide you through the following topics. So, Elisa, stage is yours.
Niklas, thank you so much for kind words, to you, Carsten, as well. Thank you so much for giving us the opportunity of organizing this webinar. I think we had a lot of topics to talk about during our preparation, but also some fun, because it was a very nice group of people that you will all now get to meet. As Niklas said, the first session is called Tricks and Traps, Evidence Procedures before German National and European IP Authorities. This is an attorney's point of view. And then the moderators, the speakers have decided to integrate the following sessions, so session 2 to the session 1. So we won't have a break between, which is a conversation with a former presiding judge, Rainer Engels. So for you to know who is giving you the presentation, I will talk a little bit about the speakers. So the first speaker we have will be Markus Oystermann from the Munich-based law firm DTS. He is a German and European patent attorney with a technical background in medical engineering, gained at the universities of Ulm as well as Munich. He's active not only in prosecution but also in litigation in front of courts and as well as patent offices. Then the second speaker will be Rebecca Hendrich. She's an attorney at law and partner at the Hendrich law firm, based in Germany as well. And she focuses on trademark and design law as well as unfair competition. And she's also, which is quite useful for this topic, active in litigation and office proceedings. And then starting at 11 o'clock, Rainer Engels will join. He's a former presiding judge but he has a long history and a long career. So he has been a judge for criminal and civil law at the Inferior Court of Kassel and Regional Supreme Court, in Frankfurt for over 15 years. And for the following 20 years, he has been a judge at the Federal Patent Court of Munich for trademarks and patents in appeal and nullity courts, and has been a presiding judge of this court starting in 2012. So we will have a very, very interesting interview partner, which will give us a lot of insights in the topic that we are discussing today. And he also is, well, after his career as a judge, he started his career as a lawyer as well as an expert for patent law in 2019. The panel has asked us to tell you that they would like to integrate your questions and your thoughts that Nicholas told you. You can type them in via the Q&A button or via the chat function in session 2 during the conversation, during the interview with Rainer Engels. So feel free to type in whatever your thoughts are, and I'm sure we will keep everything in mind and then discuss everything in session 2. So Markus, I think you're the one starting. Have a good talk.
Thank you, Elisa, for the very kind and brief introduction. Also Carsten, and of course also Niklas, for your very kind words to open up our today's webinar. As already indicated, we will be talking about for the next 45 minutes approximately about the tricks and traps, evidence procedures in the German context as well as in the European context. Part 1 now, 45 minutes approximately, the attorney's point of view, of course. Me, Markus Oystermann, as well as Rebecca, my highly valued colleague. So let's start off with today's webinar, the EPO. Maybe 1-2 sentences in advance also for today's webinar. Of course, evidence proceedings are a very, very huge topic. So we will try to give you an overview and of course maybe to highlight some specific points of it, but it cannot be exhaustive without any doubt. So considering the EPO, of course, patents, where is evidence and gathering evidence, providing evidence important at all? So the EPO is rather clear in this respect, of course. It's before all of its organs. So this means not only examining divisions, opposition divisions, of course, or the boards of appeal, but also the legal division, which maybe not a lot of us have been in contact with so far, as well as the receiving sections of the EPO, and also the search divisions of the EPO, of course, taking care of the prior art search before the case is forwarded to the examining divisions. So this also gives already a brief overview of what the particular aspects of providing evidence may be. So taking a look at examining divisions, of course, this is about maybe public prior use, which is also very important before the opposition divisions, but it's also about maybe the case constellation about handing over priority rights, and so on and so on. So it's a formal relevant, providing evidence is relevant in a formal aspect, as well as with regard to the substantial examination, of course. And as mentioned already, public prior use is probably the most important, most well-known area besides the priority rights, which require such evidence. So what does the EPO allow at all as evidence? Is it restricted or not? So Article 117 EPC gives us an overview. It's, of course, hearing the parties is also considered as providing evidence. So just what you as a representative provide as statements before the opposition division, for example. It's also production of documents, which refers to, in German, Urkunden, so like prior art documents, for example. It's the hearing of witnesses, if you have some, to make statements in front of the respective organ of the EPO, or, which is maybe not that often the case, opinions by experts, which have to provide statements about circumstances concerning the respective topic. And of course also sworn statements in writing, which can be then provided by additional persons like witnesses and so on, which is maybe also not that often the case, but can occur, of course. So what is important to notify is pointed out on the right of the slide in red. This list is non-exhaustive. So there is no restriction by the EPC what kind of proof or evidence can be provided, what kind of means, but it has to support, of course, the statements you want to make to outline your arguments. So going on with some basic principles before the EPO and its organs about providing evidence. As mentioned before, of course, non-exhaustive, but we want to try to give you an overview of what are the borders and the cornerstones of providing evidence. First of all, well-known principle probably, discretion of the EPO departments to admit means of evidence. Of course, the department or the organ itself decides about whether provided evidence is admitted or not. Two prominent points in this regard is, of course, the topic of late filings before maybe the opposition divisions and the boards of appeal. Every time, more or less, a discussion about it. On the other hand, the respective department of the EPO also has to consider whether such evidence is useful for the case at all. So if it's not useful, of course, if it's not supporting the case itself, then it may also be refused like being non-useful. But this is something which is, of course, more or less on the side of the EPO to decide, as well as the late filing, without a doubt. But with regard to the late filing, you can at least, as a representative, do something about it. Exactly, just file it right away as early as possible. And it's, of course, beneficial to do this, for example, within the opposition period. Second basic principle before the EPO, this is about the free evaluation of evidence. So what does this mean? It's like freie Beweiswürdigung in German. And this does state nothing else than every type of evidence, every means of evidence is basically considered or looked at the same way at first, and thus considered to comprise the same value of proof. So the EPC itself does not differentiate between the certain means of evidence, but it's just right away saying something like, okay, every kind of means is considered at first sight, at least, the same way, and then it has to be considered in the ongoing evidence procedure how this has to be rated. Next basic principle, duty to submit all relevant facts. Of course, it's on the parties to support their case and their arguments. And so there's something like the burden of proof to just provide every evidence, every fact which is supportive for your arguments. So not like we will come to this in the next point. It's more like that you have to support your own case to every extent. And when does some kind of reversal of burden of proof occur in the next bullet point on the slide? Yeah, there are rather rare cases when this may be present or may be the case. In particular, if so-called prima facie evidence is provided. So in German, this would be the Anscheinsbeweis, so a fact which is not directly proven, but only a proof or an evidence is provided that it's usually according to real life experience, the case that the specific fact has taken place. Then the burden of proof may be reversed, and the other party can then provide or has then the duty to provide counter evidence, which, however, would be sufficient to raise doubts about such prima facie evidence. So to raise doubts about that, according to real life experience, the indirectly proven fact has taken place in the end. This may already be sufficient to comply with the reversal of burden of proof in this regard. And as mentioned before, such reverse is just rather rarely the case, but it may occur. And so just be prepared for something like that, but don't rely on statements like probably often seen in opposition proceedings, for example, that some of the parties are saying something like, oh yeah, we have provided enough evidence, so now it's about the adverse party to make their case out of it. Okay, so third bullet point on the slide. Of course, we all know about how the EPO is in the meantime dealing with video conferences. And so it's also, of course, since January 1st, 2021, the case that also evidence itself can be taken in such video conferences. Coming to the last basic principle I want to outline for you today, it's the standard of proof, which may also be, in some cases, part of the discussion itself, of the substantial discussions. So there are three principles known by the EPC. First of all, it's about setting out facts. In Germany, that's the Glaubhaftmachung, so that's the most low kind of standard of proof. It's just like saying what was the case, saying, okay, this has been, this and this has taken place. So lining out what the circumstances have been. This is in particular relevant for the reestablishment of rights and for requests to conserve evidence in the end. And so these are more or less the two most known parts of the EPC where such rather low burden of proof or standard of proof is relevant. More often, the next two standard of proof rules or levels are of interest for you as representatives. This is on the one hand, balance of probabilities, and on the other one, this is beyond reasonable doubt. And I assume that all of you have maybe heard about these two standards already. Balance of probabilities is the usual one. So this is the one which is also applied to all kinds of evidence from the very beginning. As mentioned before, it's about the free evaluation of evidence, and balance of probabilities is the corresponding standard of proof being applied. It cannot be taken like, okay, if we have 51% of certainty about something, this should be sufficient. It needs to be, of course, little bit more, but it's still about, okay, is it probable, or is the probability that something has, a fact has occurred, is it more likely or not? This is sufficient to be in conformity with this balance of probabilities standard. On the other hand, beyond reasonable doubt, this is the highest one, which the EPC is usually dealing with. And this particularly comes to life when, for example, in evidence or in proceedings where evidence is provided, such evidence is only accessible or available by one party. So like emails being sent through the internet, or some kind of internal knowledge which is provided as background knowledge of the skilled person, stuff like that being only accessible by such one of the two parties, the at least two parties. Such evidence then has to provide or be in conformity with the standard of beyond reasonable doubt. So really convincing without any point lacking, more or less, yes. So this is really going to the top of evidence in the end. Okay, so in the next step, I would like to put the spotlight on two of the previously mentioned means of evidence. On the one hand, internet disclosures, which from my perspective at least are becoming more and more relevant, especially in the last decade. And on the other hand, on the next slides, I would like to put the spotlight on hearing of witnesses, which is of course maybe the most arguable means of evidence, because a lot of different circumstances can take place in such a respect. So first of all, going on the internet disclosures. As mentioned, from my point of view, increased importance in the last years due to several facts. Of course, accessibility to the internet has evolved in the last 20 years approximately, but also social media has increased a lot. Advertisement material is shared via the internet a lot, so it's not like in previous times that you get sent printed catalogs of flyers all the time, but a lot of things are now going via emails, for example, or through social media, of course, or via the firm's own homepages. But we also, in the next step, have the Wayback Machines available so that you can really determine what happened maybe 20 years ago on a certain homepage, what was the status of the homepage, what was the disclosure on at this point in time, so that you can, even if it's not available today anymore, or you have a patent which has a filing date in 2012 or priority date in 2012, you can still try to reconstellate or redesign what was the disclosure on the internet at such previous point in time. So this eases a lot, I think, how to provide evidence, especially on my side. I had a case like 2-3 years ago approximately, which was about a opposition proceeding, and luckily I hit up on a disclosure of a flyer which pointed out a certain event dealing with the topic the patent in suit was about, and it was right on the certain day of the filing date of the patent in suit. So the disclosure itself was, of course, at this point in time not novelty destroying for the patent in suit, but it gave really good indications about what has happened and what would have been was necessarily public before such detrimental date. And without the internet, to be honest, there would have been no chance to hit up on such flyer or such advertisement. So it's really useful to do your own investigations also on the internet, but not only to try to get every time the advertisement material in printed form. Okay, yeah, second bullet point on the slide, of course, internet disclosure often also has the beneficial effect of providing specific and determinable dates of disclosure, as you can rather easy then, for example, via the Wayback Machines, identify what was the status quo like 2 years ago, for example, or 10 years ago even. So this eases the argumentation and the evidence being provided a lot. And on the other hand, going on the standard of proofs, of course, as it's accessible for both parties, for both sides, You only have to comply with the lower standard of proof in this one, not only the balance of probabilities, but not going beyond the reasonable doubt, of course, as the highest one. So it also eases the whole proceeding for you if you have such rather easily accessible evidence. Okay, next point, hearing of witnesses. As outlined before, I would assume that this is the most, that's the holy grail probably of providing evidence in the end. Keeping the blood pressure high usually, as you never know what will happen in front of the court, or now with regard to the EPO, of course, before like the opposition division. What has to be mentioned in this respect, hearing of witnesses, always request, if you want to have witnesses in such proceedings, always request, file a specific request that such witness shall be heard. And this needs to be an explicit request indeed, which not only states out the facts which has to be outlined by the witness, but if there is no particular explicit request to hear the witness, then for example, the opposition division or the organ of the EPO cannot summon the witness. So you need to have such request. It's not about only offering to hear a witness, it's really requesting to hear the witness. And then the respective organ of the EPO will summon the witness if it's considered useful for the case in the end. What's also interesting about the hearing of witnesses is simply that such witness hearing can be a kind of supplementation for the facts which has been provided by other evidence, for example, concerning public prior use. So the hearing of the witness can then supplement some lacks of previously provided evidence, for example. And these supplementing facts are not considered as new facts, but only as supplementing ones. So there's also no late filing issues or no late provided evidence in this respect, but it's only a supplementation or considered as a supplementation of facts. So always keep in mind, if you are not sure whether maybe your public prior use argumentation is really like to the point, then maybe if it's available at all, of course, then maybe the hearing of witnesses may be useful. And then the last point on the slide, the hearing of witnesses, of course, something opposition divisions or the boards of appeal are rather reluctant to execute in the end because it brings a lot of uncertainty. It's really a huge workload they have to cope with in this regard to execute this hearing. And so it's usually only admitted by the EPO and its organs if it's really considered useful on the other hand, but they also usually admit it before they reject the alternative evidence which may be supplemented by such hearing of witnesses. So if you have a sworn statement, for example, and this has some holes in it, like lacking some certain points which are very important for the case, then maybe it will be useful not only for you to file a specific request to hear the respective witness, but the EPO will not reject the sworn statement before it has heard the witness. Okay, coming to the takeaways, the tricks and traps indeed, which you may be waiting for now since the last minutes. I lined out some of them, so 4 to 5 overall. Starting off, as a summary, of course, in this respect, evidence is only accessible by one party. Then try to go on with maybe internet disclosures, as mentioned before. This is really huge in its accessibility, and it's only making use of the standard of proof being not, in this particular case, not raised, of course, sorry for that one, not raised to beyond reasonable doubt, but it's dealing with the usual standard of proof rule. then only offering hearing of a witness is, of course, a trap. You need, on the one hand, to line out the facts, to outline the facts, which has to be proven by the hearing of the witnesses, but also you have to file the explicit request as mentioned before. Without such explicit request, the EPO's organ cannot summon the witness. Then going on with means of evidence being not bulletproof, I mentioned that earlier. If it's possible for you in your case and the client can provide maybe a witness, then request the hearing of such witness just to make sure that you really get everything out of the case and that the EPO may not reject the evidence, the previously provided evidence, but will summon the witness to supplement such evidence being provided before. And then, of course, maybe something which also takes place in some cases, the objection that a witness shall be biased. That's very interesting because the EPO does not consider such bias of witness as a question of admissibility, but it's part of the free evaluation of evidence. So the EPO's organ will hear the witness and then consider what about its credibility in the end. So that's again going on to the standards and the specific standards of the EPO, how to deal with evidence and the respective concept of freedom of evaluation of evidence in the end. So as mentioned, bias of witness, the EPO will decide about that one. Okay, thank you very much so far. So I will now hand over to my colleague Rebecca. She will go on with the German part of it. Thank you.
Thank you, Marcus, very much. I'm not sure if you can already see me. Yes, should work perfect. I will continue with the German IP authorities after Marcus gave his very detailed overview over EPO proceedings, and my nod will make the slides go further, I guess. Perfect, thank you. This is a very brief overview, of course, over the German IP landscape. What you see in blue in the upper line is the German Patent and Trademark Office, the Federal Patent Court, and the Federal Court of Justice, which form one track of our IP landscape, namely the filing track, and filing opposition procedures, cancellation procedures, all take place mostly at our IP offices and then by appeal to the Federal Patent Court. So this would be true for trademarks, patents, designs, utility models. So it is a very important track, of course. If you deal with an infringement, you would have to use the second track to our ordinary courts, the district court, which appeals or which decisions are to be appealed to the higher district court. And something that might be special is that the district courts in trademark proceedings are also competent to deal with cancellations if the cancellation is based on a prior right which is not part of the GPTO proceedings, for example, for copyright. So if you want to claim that your copyright is infringed by a trademark filing, you would have to use a cancellation procedure at the green track and the ordinary courts. But today we will only concentrate with the next slide on the part between the GPTO and the Federal Patent Court, because there are a few specialties in the evidence proceedings in comparison to the EPO, of course, but also in comparison to the ordinary infringement courts. So all what we will discuss today will take place in the registration and examination stage, opposition proceedings, and also cancellation proceedings on absolute or relative grounds. So this is where we are today. And in trademarks, the most relevant topics for evidence proceedings would be to prove the public recognition of a trademark. this is the most common point or the most common question you have to answer if you want to register your trademark, which might be, or which might have no or low degree of distinctiveness, or rather no distinctiveness. And you would always have to do that if you want to register a special kind of trademark, such as color trademarks, or maybe a 3D, a shape trademark. So this is a very important point. Then of course you can prove how the public would understand a trademark sign, or how the consumer would see a trademark and understand it. The next bullet point is also very important, and for those of you who work in trademark law, you always have to put enormous effort into proving use of your trademark, and this also is comprehensive for proving the existence of non-registered trademark rights, such as a non-registered trade name, which just grows into existence by use. So this would be also a very important point for evidence procedures. The next 2 points are also kind of self-explicit, because you would always have to introduce to the office or the court how your very famous trademark was damaged by some infringer, and how the filing would damage your reputation further. The same goes for bad faith applications. The next slide, please. Thank you very much. The basic principle at the German Patent and Trademark Office and at the Federal Patent Court itself is that the office has to investigate most questions, actually, but, and that would be a very big but, the parties have an obligation to cooperate with the office and the court, of course, and the basic principle of official investigation is rather turned around for a lot of very important questions, especially in relation to prior rights. If you want to prove that you always have to prove that you have prior right, so you have to identify your prior right, you have to put very detailed substantiation regarding the existence of your prior rights. This, of course, can be very easy for registered trademarks, if your prior right is a registered trademark, but for some other, like trade name rights, it might be a bit tricky. And then, of course, there's a very big principle in relation to use. In relation to use, it is always the one who claims to hold the right who has to prove the use. As you may see on the next slide, is that this is a principle going throughout all trademark proceedings in Germany, and it should now be harmonized around Europe. It is always the holder of the prior trademark who has to prove that he used his trademark if it is out of a grace period of 5 years. So if you are attacked by someone with an older trademark, you can always claim that it was not used, and you do not have to substantiate it or lay out any details about the non-use. So it is in all of the proceedings, in opposition proceedings, in cancellation proceedings, it is always the holder who has to prove use. And then we can go on to the next slide. Thank you. And how to do that is very specific at the German Patent and Trademark Office, because this is a specialty in the German IP landscape. To prove that you have used your older trademark in opposition proceedings, you have a bit of an easygoing way. You just have to make it credible. This is something, a principle Marcus mentioned earlier. To make something credible means it only has to be, or only has to have an overwhelming probability. There's nothing certain here, just have to be probable or credible. And for that, you can use a very special or type of evidence, which is an affidavit. You will hear about that quite a bit from me, because there are a few specifics you have to watch out in Germany. The affidavit always has to be signed by a natural person, which is somewhat clear that you can't have it signed by a legal entity. And it should always be manually signed, so really by hand, so that the German criminal acts demands are fulfilled to give it its full weight. And with that, we can go to the next slide, which shows the very different degree of conviction, which is usually used. So a very different standard of proof usually. At the Federal Patent Court, the judges should always find a personal certainty. That means they have to find a degree of certainty that is useful for practical life and that silences doubts without excluding them completely. This, as you can see, was stated out in a federal court decision, which was quite peculiar, as a young, not so young lady claimed to be the daughter of the last Russian Tsar. And the court did not believe her, and in this decision laid out the degree of certainty that the judge must come to. And where you can see that also found its way into the German Trademark Act. So also the judges at the Federal Patent Court, as well as the infringing courts, have to believe an allegation to be true. They have to come close to personal certainty. Next slide, please. Thank you. This is where we can see how these principles play together at the example of recognition in public. So if you want to prove that your trademark is recognized in public, you need all three of these points. First, you have to make the trademark use credible, and not only the use, but the public recognition of the use. That you can do with an affidavit, for example, so a statement in lieu of an oath. And you have to substantiate the presentation of facts as detailed as possible. They can all serve as circumstantial evidence. And only then the office is obliged to investigate further. So this would be then coming back to the principle of official investigation. And then the end result of that would have to be that the judges or the office come close to certainty that the trademark is recognized in public. What we see here would be that the same as with the German Patent and Trademark Office, the topics at the Federal Patent Court for trademarks where evidence rendering or is taking place are mostly the same. So it would be mostly about public recognition of a trademark, applications in bad faith, or trademark use. And over these slides, you can go a bit quicker, Marcus, as we run a bit low on time. You always have to substantiate it. This is the trick. You can't rely on the official investigation. You always have to give starting points. So always try to have in mind that you make your points very clear and very credible, as substantiated as possible. How you can do that is something what I want to go on backwards. So starting with the Federal Patent Court. The the types of evidence you can use are not limited at the Federal Patent Court, but they are at the infringement court. So there's some differences here that I want to lay out. At the infringement courts, you can only use the types of evidences you see here. So personal examination by the judge, you can use public and private records and documents, experts or expert witnesses, normal, usual witnesses without further expertise, and you can request a party hearing. For infringement courts, that's all. At the Federal Patent Court, thank you. At the Federal Patent Court, you can, the court, because of the principle of official investigation, is more freely in its determination which types of evidence it wants to hear. But it is also free in the evaluation. So there's no specific ranking of the evidence per se. Of course, there's a certain, let's say, hint that the party itself might be a bit biased in favor for its own case. So there's always this to consider in the evaluation, but in principle, the evaluation is to be made freely by the judge. Perfect, thank you. We can continue with the next slide, which goes back to a very important point. The affidavit has something of a special position in the German IP landscape. It is very common to use an affidavit to make something credible, but you have to be careful because at the Federal Patent Court, the value of an affidavit has to be re-evaluated in comparison to the opposition procedure at the GPTO. So what you want to do at the Federal Patent Court is you want to make sure that your affidavit also could be taken as a written witness statement. Exactly, like that. And to make sure that the Federal Patent Court has to hear your witness, if it is not fully convinced by the affidavit itself, you should always request the hearing of the witness. And the judge can only have a chance to be convinced by a written witness statement or an affidavit if it is usually it is necessary to support the allegations in the affidavit with additional facts. Not only facts, but of course, facts presented by evidence. To make sure that your affidavit is usable in a German court, it has to contain a statement that the person is aware of the significance and that he is aware of the punishability of a false affidavit, and this might even be process fraud. So as a German counsel or international counsel, you want to make sure that the person giving the affidavit is aware of these facts and liabilities. I will close with the German spotlight or the German view on the various evidence materials in the internet, as Marcus pointed out earlier, which are all examination materials. So they usually are no public records with a high degree of credibility, but they are all open to be evaluated freely. They do not per se deliver full proof of their content. So you can always, as a counsel, find reason for doubt. And you should, especially with something like a Wikipedia page or a Google search, you should ask your client if the content is plausible. As we all know, Google searches appear to be personalized regarding to your IP address, your search history. And we all know that Wikipedia pages can be edited by nearly everyone, and that would have to be weighed in the evidential value of these evidence materials. Regarding emails, they are handled a bit differently than by the APO, because they don't, if you want to lay out emails which are only one-sided evidence material, it does not change the standard of proof, but they are also to be evaluated by the same standard, and the judge still might find that they are enough to fully convince him to his personal degree of certainty. If they are, example, supported by further evidence, an email could be enough. But again, if you can raise doubt about the truthfulness of the content, they also cannot be enough. So no inherent value of emails. This is something you should take away. This is a point which is very important in trademark cases, because your clients often want to prove trademark use by using screenshots of their website showing the trademark. They say this is how we use our trademark, but you always have to keep in mind that the website on its own has no informational value, and that means really zero in relation to the scope of use of a trademark. So as a counsel, you have to really urge your clients to dig for more information about clicks and views and really the reach of their websites. And the same would go, for example, for YouTube videos. So only a screenshot of the video itself would not be sufficient, but you would have to count the clicks and submit the clicks to the office or the court. Thank you. Now I will close with the last slide of part 1, which are a few hints about the hearing itself. Evidence is always taken in a hearing. The hearing is public as soon as the trademark or the right that is concerned is published. Upon request, you can request that the hearing may be held in private if specific interests are concerned. What you also want to have in mind is that in Germany, as in a lot of countries, IP infringement is a criminal offense. So witnesses might be or might have the right to refuse to testify if they would bring themselves in troubles regarding to an IP infringement action. What you also want to know if you're an international counsel, that the evidence has to be evaluated in the hearing. It can happen that a further deadline for a written evaluation is given, but it is not the usual case. So as an international counsel, you want to fully brief your German representative about any doubts or critiques or implausibilities in the letters of the adversary party. And in the end, what you always have to do if you have a complaint about the lack of investigation, so if the office or the court violated their obligation of official investigation, you should complain about that in the hearing. You should make sure that it is documented in the official minutes of the hearing. And of course, you should repeat your evidence requests in every further hearing that might take place. And with these last points, I close part 1 of our presentation. And thank you for your attention. And I am very happy and honored to have with us today Mr. Rainer Engels, who will discuss with us certain practical parts, which we touched in our theoretical presentations, and who is also open to questions from your side, which you can just put in the Q&A chat you can see at the bottom of your screen. And with that, I see, Marcus, you're already there again. That's perfect.
Yes, thank you, Rebecca, for this very interesting insights into the German proceedings, with particular focus, of course, on the trademark side. Elisa, you want to briefly step in for a brief introduction?
Sure, I can. I would just repeat myself a little bit regarding my prior point that I told you before. So for all the people joining now, Rainer Engels is a very well-known judge in Germany. He has been a judge for criminal and civil law at the Inferior Court of Kassel and Regional Supreme Court in Frankfurt for over 15 years. And for over 20 years, he has worked at the Federal Patent Court of Munich for trademarks and patents in appeal and nullity proceedings. And from 2012 on, he was a presiding judge at this same court. So we're very happy to have you here, and we're really looking forward to the conversation you're having, or you're going to have right now, until 11:45. And after that, for all the people wanting a little coffee and not wanting to miss anything now, we'll have a break until noon, but I'll talk about that once we reach the time. So have a good conversation.
Yes. Can you hear me?
Yes.
Yes.
Good morning, Rainer.
Yes. Good morning.
Thank you, Elisa.
Yes.
Thank you.
Nice to meet you all.
Thank you, Elisa, for the
presentation.
introduction. Rainer, good morning to you. Thank you very much for your time. To have you as a guest, it's a real honor, and we hope we can really have now an interesting discussion about the evidence proceedings, of course. Maybe kicking off our conversation with the first, rather easy topic probably for you. Anyway, my question to you at first, from your experience, what are from your perspective, the main grounds concerning invalidity of patents? Of course, as you have been to the Fourth Nullity Senate recently, what are the main grounds in invalidity proceedings when rendering evidence was most prominent, most important?
Perhaps I should start that what you have told about trademarks and the rules and principles. In principle, we have the same rules, and we have a rule here or an article. It is 73. It is quite the same like in trademark. And what is very important you told about that is that the Federal Patent Court in general is investigating the matter ex officio. This is the most important thing we should know. And it is therefore not bound to the submission and evidence submitted by the parties. That is the different to the civil court, that we can take evidence ex officio, and therefore we take evidence not only if the parties want that and apply for that. We can take evidence if we think it is necessary to find out what is the real thing about the patent or the situation or the investigation and different the prior use and so on. And going to your question, what is the most important thing? I think I should say at first that the take evidence is not so important as it is in civil court. It is not the normal procedure situation. It is an exception. We deal with that only sometimes a year, perhaps in 10% of the cases we take evidence, or 5%. Therefore, if we take it, the most important case is that we have a prior use. You told about that prior use. Of course, we need the facts, what is shown in prior use and what can we see, what machine, what situation. I will talk about that if you question about that later, what is a special problem of prior use. Of course, we have a situation of lack of patentability. Sometimes we need evidence too, but normally we have the documents and therefore we don't need that, and there is no discussion between the parties. And if we have no discussion, there's no necessity to prove it. And what is important, we can take evidence when it is necessary to clarify the facts, and we do that. But normally it is only necessary if we have facts which are discussed between the parties, and there is a reason to do that. And the third situation perhaps is what is a special German ground for revocation is this the fact of unlawful deprivation. But this is a case we deal once or twice a year, not more. And then, of course, we have the fact what happened in the in this situation of the patent writing, and is it an invention, or who is the inventor of that? And if there's a discussion, then perhaps it could be necessary to discuss it and to take evidence. But a very untypical situation for us too. Therefore, if I should sum up it, for us it is an exception that we do it, and we do it, you told that, with the same rules the civil judge do it, but we can do it in the situation we need it, and not the parties apply for that. That is the difference. And we have the same formal evidence procedure, and we have the same formal evidence you have in the civil law, the experts and so on, the document and visual inspection and so on. You told about that. There's no difference about that, because we use the articles of the civil of the ZPO, of the civil procedure rules.
Just if I might add in a short question, because you said you are allowed to investigate on your own. Does that comprise suggesting evidence?
Yes. What do you think about if you ask suggesting? What case do you think about?
Like a certain witness could be useful for this case, but might not have been named by name by a party. Yeah,
we can choose it, and we can say we need an expert, or we need a visual inspection if it is better to take evidence. There are we completely free to do that. It is the expression of our general working, and the investigation ex officio. This is one of expression of this rule or principle.
Okay, so rather big freedom for the court in this part.
Yes, but for us, of course, because we have technical problems, experts can be very sensible, but it is an exception too. You have to know that the German court or the Federal Patent Office says our examiners and the judges are experts too. And therefore, normally we need no expert for taking evidence or understanding the technical teaching. And therefore, I think in my practice, I have for example, less than 10 cases, we need an expert from outside for understanding or taking evidence to the technical teaching of the patent. A very rare situation.
But again, regarding the hearing of witnesses, it sounds to me like, or at least I anticipated, and that's also my experience, at least maybe you can confirm, that hearing of witnesses is, at least in the invalidity proceedings or in proceedings before the Federal Patent Court, rather more or less the last measure. So you try to rely, of course, on the written documentation and the written evidence as far as possible, right? Not only due to the workload which this creates, but also to certain uncertainties. Is that correct?
Yes, this is correct. We have the same problems the civil judge has, because take witness, you couldn't be sure that is truth what he will say, because our memory is not perfect. And if I had a document that is better to prove a situation or a content of a fact. Of course, we take it, but you have to take it if you have no choice, because you have no other possibility to take proof. Then you have to take the witness.
What might be often the case in IP case is that we have kind of an intermingling or several proceedings where a witness might be heard in one proceeding, for example, in an EPO proceeding. I think this is something you pointed out, Marcus. And could you then give these minutes or the protocol and use it in front of the Federal Patent Court?
Of course, you can use it, and we take the minutes and we will take them in the procedure and send them to the parties, and they can make a statement, and we can say, should we take evidence more and should we repeat this? But if one party wants that we take witness again, because he said this is not the truth what he said, I want to take my own questions, then we have to repeat it. And we have the same problem as every judge has in other cases, that he has to take witness in front of his own court in his own oral hearing, because he need unlimited expression of the behavior of what is also around the text of the witness, and therefore it is very necessary to do it yourself, because what is written is not the same as that what is said in front of you.
And you're already reached out to the thing that remembering something which is maybe 5-10 years ago is even harder than having something as a written statement, of course. And now going to the context of private companies, for example, if now one party maybe provides some kind of witness being the leader of a department, and he denies like everything which happened under his potential duty to oversee, how do you deal with something like that? So
yes, I think these are different situations. The first is that, of course, it is difficult to remember things that are in past or 10 or 20 years, but it is possible, because if you have to remember very important things, then you can do it. And I think sometimes what we ask are often very important things if you think at the inventor and the situation of invention. And of course, he will repeat his, he will remember this in a situation 20 years ago or 30 years ago, because he will not forget this. And there are other situations you can repeat, not the normal thing of what happens in the week, but this is not interesting for us. And I know that often we have success with these questions, and that the inventor or the responsible person will remember the construction, the problems he had, the discussions with his colleagues and so on. This is possible. And what is the question if the other party deny everything? We have the same situation we have in civil procedure order. You told about that, and we have this rule 138, I think so, that you have to substantiate what you have seen yourself and what you have heard. You cannot say, I don't remember. This is not allowed. We have the same rule in our procedure. And the other situation is if he said, I'm not responsible for that in my organization, and he's a leader of a group and so on, we have the same rule that is, we say in case law, that he is has a duty to take information from his colleagues, and he cannot say, I'm not informed. This is the same as not a correct denying, and it is not relevant. Therefore, he has the responsible referring to the organization of his company. And then we say, you have time enough to ask, what did your worker do with this car or whatever has to discuss. And therefore, there's no difference to the my colleagues to the civil law.
So the counsel of a party would have to advise the party to really dig deep into their records to refresh their memories.
Yes,
okay.
Of course. And if you say, I can't say what we ordered in 2003 and how many cars and so on, we have to say, of course, look in your books, look what is documented and bring it here to us. You can't say, I have to do nothing. I'm not amused about coming here and therefore I will not do that. Then the party who has to bring the
Evidence.
They have to bring the evidence, lack the burden of proof.
Okay. And would you say that, because we're just now at the witness theme, would you say that it might be useful for the party to just have a witness present in the hearing, even if the witness was not summoned yet?
Yes, this could be interesting, because you not ever know what's going on in the oral hearing and what would be the situation after discussion a while. And then perhaps you have a situation that it could be necessary to make it clear with evidence, with document, or perhaps with a constructor of the machine and so on. And then we have this situation that he works as an expert, or that he is an expert witness. You know, we have this situation that a witness could be an expert too. And of course, we often have this because the people who work with the technique are often technical experts too. And then it could be very interesting that he can explain the court what is the different working of this device and so on, and what was the problem for the investigator to solve. And this could be very interesting for some question of patentability and so on, and to understanding for sufficient disclosure and so on. And therefore, if you think it is could be very important, therefore you should do that. And you should bring them to the court, and you can say, of course, I have, if it is necessary, I have here some documents or some witness and so on, and the court knows that. You should say this to the court.
Okay, so it might just lower the threshold of actual taking evidence, because you might get under the impression that courts in general, not only the Federal Patent Court, are somewhat trying to avoid a very lengthy evidence taking.
Yes, every judge try to avoid this, and but it's the job to do that, and there's no reason that it is very hard work to do that. Sometimes what is our special problem, that often the people who have to take witness are not in Germany, and they live in United States, in Great Britain or French, and they are not obliged to come here. And therefore we have to take a witness in the country they live. And this is very hard work and takes a long time. Or you agree with the parties and you make it on television or on
a video
on some modern visual like we do here. You can do it. You told about that, that the procedure allows it, and this is not, of course, a solution that we talk about him in a Zoom meeting and so on.
And have you seen an increase in video conference?
Yes, of course.
Hearings.
Yes, of course. You know, the parties often are interested to do it quickly. And they know if we send the documents to United States and say we need some witness there, we will need 1 year and more to get it back. Because it is very complicated way. You can't send it to the judge there. You have to go about all the Botschaft,
embassy,
and so on,
embassy
and so on, and it's very long way to do that.
Maybe coming shortly back to the circumstances of the oral hearing itself, what would you recommend how to behave if in the preparation it turned out, oh yeah, our client has a certain witness which may be of interest, I bring them to the oral hearing? What would be the procedure for the representative in the course of the oral hearing? So right at the beginning or during the hearing when it's becoming relevant, or what would be your recommendation for our young practitioners being present today?
Yeah, you should present him in the beginning of the oral hearing. You should talk with the judge and say, I think this could be useful that we will hear him, and he can wait on the floor or everywhere, and later we can hear him if necessary, and if not, we go home. But what is the most important thing? You should talk with the person who has to take witness. What is what he knows and what he will say. Otherwise, you could get a bad surprise that he will say the wrong thing. You should clear up what is his what is his witness.
So preparing them.
Yes, not preparing them. This is not so good, because the judge will find out that he always says what the representative want. You should not influence him. This is not allowed, and it is not good, because the judge will find out it. If the person remember all details, he couldn't remember normally. He should be a special person, or he's instructed, and that is a bad result. And therefore you should ask, can you tell me about that? What do you remember? Do you have documents at home that could help you to remember, that you can bring this to the court? Are there other persons who could help us to take for the evidence? This is the work of the representative to do with him, and then shoot him alone, leave him alone, and he will ask the questions of the judges.
And was there any situation in your career where you really had doubts about not the independence, but about the attitude of the respective witness?
Yes, of course.
How did you deal with that one?
Yes, I say him, judges work differently, but I say, I don't believe you. What you say, this doesn't happen this way. You cannot remember this really. I think you are instructed. I said him that. And I will him say, of course, you know that perhaps we have take oath of that, and you will get punished if you said the wrong thing, and we should work with. We should not work hard with that, but we can say what is the reality, and that you have to go to prison for 1 year or more if we could find out that he didn't say the truth, and then the other thing is, of course, the practice of take evidence. You have to confrontate the persons who take witness and say, okay, he said that. What do you say about that? You know, this is cross evidence in United States. We don't have it in this expression way they have, but we can do it, and we can confrontate him with some situations and with some witness or with some documents or what he said in the other court, and say, last year in civil court you said to the judge this, and I say to him, okay, what do you say now? You say something another
different.
Yes, and then you can see, oh, can I believe him that he now said the truth, or did he change it because the situation needs it, because he want to give a good oath or a good situation for his colleagues or so on. You have to find out it, like every judge in the world has to do it.
So in case of contradicting statements by a certain witness in different proceedings, you are dealing with the respective statements according to the probability, right?
Yes.
So
yes,
okay.
And you can repeat the questioning and so on. You have different possibilities. Of course, you know that you never will find always the truth. Any judge of the world can do this, and in criminal law it is nothing else than in criminal law. And of course we have parties and witness which deals with special interests, and we know that, and we have always the risk that they won't make a fine deal with the inventor because they works together and so on. This is the problem.
So that we now reached like more the evaluation of evidence, I might want to put a little switch to, let's call it paper documents or written documentation. Would you say that, of course, public records should be the most convincing records? And we heard earlier from Marcus that the EPO has a very, for me as a trademark lawyer, a rather special approach to one-sided evidence like emails or internal evidence. Is there a rule, or maybe you evolved a personal practice on what documents you usually find convincing?
This is difficult. I think this is it depends on the case. What is the rule? You said is right, that the documentary evidence we have to differentiate the private documents and the what's the name of that? The official documents.
Yeah, public records.
Public records, and only the public records give evidence about the content, what is written. And the private documents only give a proof of its creation, that the person who writes it and makes it really does it, and that we have this documented. It is not a fake, but what is written in is cannot be proved about that. That you can only with these official documents, and therefore you sometimes need a further evidence questioning the person who wrote it in the document and said, is it right that you make this document and that you wrote there, we buy this machine at April so and that we pay about so and so $1 about that? And he says, yes, of course, this is my document. I write it myself. And then you have two evidence. Yes, you have an addition of evidence. There's a written evidence and what he told. And then you can say, okay, now I believe that. Because why not? Otherwise it should be, or there must be a fake. And then there is a situation the judge has to clear, is it a fake or can I believe him? And if I can believe him, I can believe that he wrote this document. And if I can believe that, I believe that what is written in the document is right. And perhaps he cannot remember every sentence, but if he can remember the essentials, I can say, okay, then it should be right that the whole document is okay, and that it says what really happens. This is what is the most important thing, that we should be sure about the evidence by our own feeling and opinion, and that we are free to feel that. What you say about this Anastasia file is that we should prove it with this relation. Can I believe him? Can I not? The same as in criminal law, the judge do.
Well, we all know about the theoretical possibility to fake, especially online evidence or digital evidence. What role does it play in practice? So do you see a lot of fake email conversations, or is it?
No, I didn't see, because a normal you have to know what is the reason to show this correspondence to the judge. If we had an unlawful deprivation, then we should be very critical about that, of course. But if you want to show me that you sold this or you bought this and that it is a public, that the product was in public and that some people bought this and that you sold it and brought it to the you brought it out, then there's no reason to be doubtful that it could not be right. Why? It is a normal situation in business. And then I think we should not be too critical to that. And then we can accept it. In this rule of 286, we have in the civil procedure rule, you are free to do that. You told about that in the emails some minutes ago, and we take this in the same way, that we cannot say this is not a document in the correct formal form, but we can find it as an indice or as a sufficient evidence we need. It is possible.
I was just thinking not only about Photoshop, but also about AI, which of course came to life the last recent years, and more, and dealing with alternative facts, more or less. I mean,
yes, you are right. You are right. If I would be a criminal law, I would be very careful about that. But I think normally in patent law, we are not surrounded always with gangsters. You know, this inventors and our representatives and so on are not gangsters. That they deal normally very correctly, and therefore it is not our main problem to convince us or them that he is a gangster and he is a good guy. This is not the normal situation here.
Yeah.
Okay.
Maybe coming back to a more regular point. I mean, everybody of us had it in her career, obviously, cases with a lot of evidence. So numerous numbers of documents, different witnesses, different screenshots being provided, and so on and so on. So how did you deal with that one? Like if there are 70, 80 pieces of evidence provided by the parties, and would you say it's beneficial for the case because it's just the probability that everything is on the table is more likely achieved, or would you say it's counterproductive because the focus of the parties is just destroyed on the really important things?
Yes, I think, of course, we try to avoid an extension of burden of proof. Of course, the judge has time limited, and we search for the best document, the best burden of proof, and then we start with that. And then we have the rule, if the burden of proof was successful with one document, we can't stop, because we found what we are looking for. It is not necessary to take evidence about 100 documents if the first is enough and we find out that the burden of proof has taken. The contrary party has a right in the civil procedure law for the contrary burden of proof, but if he does not, we can stop and we are finished. And
so
I never remember a case where I had to take 30, 40 different documents or witnesses and so on. This is a theoretical construct. Normally, we have to take witness about perhaps I remember one case I had 8 or 10 persons to take witness, and this is not the normal case. Normally, you have 1 or 2 persons, and then you are finished.
But just maybe putting out or coming to the example of prior public use, do you get, as a judge, do you get curious about the evidence if a party provides like 10, 15 pieces of different evidences just to prove certain thing about such public prior use? Do you get even more curious about the respective single evidences because you may have the impression that these are not as convincing as the party lines out them to be?
You have this problem, but the most important problem, especially in public prior use, is that you, in the first step, need substantiated statements of the facts. And if it is not substantiated, it is not sensible to take evidence, and it is not allowed. Because we shouldn't find out the facts with taking evidence. The party has to assert the facts, and then we have to prove them. And what that we need, therefore, is we can say perhaps 3 conditions we need from the party who wants to have the evidence: that we have the time of use, we have the object of use, and that we have the circumstances of the use. And therefore, we need a very exact, very substantiated facts. And then we can ask the person who has to take the witness and so on, can you tell me when did you this? Where was it? In which situation you did it? But we need the information before we start with that. because I'm not interested to find out what the witness possibly could say. That is very important, and we are very strict about this, because sometimes the representative doesn't know himself what he can say. And this is what I say some minutes ago. Ask him what he can say and write it down and bring it to the court and say, I will approve with him that all these facts are right. And if it is very substantiated, it is the best you can do for yourself and for him too, and for the court. And therefore we make a restriction. If you only say, I can prove that he works out this machine in 98 on the so-and-so call, in this situation, we need a substantiate pleading about that. What was his work? What position had he in the as a worker, or was he a constructor? Was he the owner of yes? And we need every information you have, and then you can take evidence. And on the other side, if you have not, I know that you will not be successful.
To what degree are you allowed to give hints to the representatives if you see this could be promising, but there is some lack of substantiation, let's say around the object of prior use? Would you try to get a more deeper substantiation in advance of a hearing, prior to a hearing?
Yes, in advance of the prior of the hearing, the advocate has to substantiate that, and he can do it in the oral hearing. Of course, he's in front of the court, and he can ask, and he can say, "Do you remember that? Or isn't it right that you did it in this way?" He can all take this question and can help to remember. This is allowed, and it is allowed. Sometimes people think it is not allowed to question or to speak with the person before the oral hearing. This is allowed because the representative has to know if it is sensible to bring him to the court, and therefore he had to interview him. This is of course allowed, and it is not a bad result for the judge if he find out that they spoke about that. This should be a normal situation.
So it sounds to me like, again, for all of our young practitioners being present today, taking evidence is to be taken serious, right?
Yes,
really putting out the respective points and not playing any games, not overthrowing the court judges with rubbish, but really concentrating on the facts. And if you cannot concentrate on the facts, like something is missing, then you should not try to play with hopes on your own case, but to try to find different lines of argumentation, right?
Yes. And you should be aware that it is an unpleasant situation for the persons who go for the first time to a court to take evidence and so on. And therefore, you have a responsibility as a representative to help you and him, and to bring him not in a very hard situation. You have to avoid this.
And I guess you would always want to rely on additional evidence.
Yes, of course.
So I think this is something what you pointed out, that a pretty good mixture of evidence materials would be the most convincing.
And if possible, experts or documents. These are the best and the most valid things you can have.
So I think, Marcus, we are running short on time, are we?
Yes, I think so. Elisa showed up. So
Okay.
seems
Very good,
like
yeah.
we have to come to an end,
Yeah.
unfortunately.
So, Rainer, we want to thank you very much for your time and your professional insights from the judges table, which was very helpful. Is there anything you want to give away to young practitioners? Your #1 trick or trap?
Oh, I don't know what I should say now. I hope they make their best and they will do it in a good way. And I think be criticful, but do it in a constructive way. If you are a representative, this is very important. And then you will be successful.
Thank you, Rainer.
Yes.
Thank you very much.
Thank you very much. I think these were very, very wise words for us to come to an end for session 1 and 2. Thank you, Rebecca. Thank you, Markus, for this very informative morning we had. And now, not to lose any time, I would say we start our break. We'll come back at 12 o'clock. So we'll have a break of about 15 minutes. You can all get some coffee, relax a little bit, and then we'll continue with the next session we have that's called Navigating the Landscape of Evidence Requirements in Civil Law and Common Law Jurisdictions. So we'll have some insights from Germany, UK, and Austria, which I believe will be very interesting. So have a good break and see you in about 15 minutes. So it's 12 o'clock. Welcome back, everyone. I hope you did all get some coffee or something to drink. We will have this presentation now until 1 p.m. Afterwards, we'll have a longer lunch break until, just let me double check. Yeah, 2:15, so 1 hour and 15 minutes. So we have 1 hour left now for our last presentation of the morning, which will be held by Anahita, Birgit, and Lucy. The three will talk about, as I said before, navigating the landscape of evidence requirements in civil law and common law jurisdictions. And I wanted to give you some information about the speakers, for you to know who they are, why they know what they're talking about. So Anahita is a dual qualified lawyer, or attorney at law to be more precise, for Germany as well as England and Wales. She's practicing in Germany and is an associate at the law firm Quinn Emanuel in Stuttgart in Germany. And her practice focuses on intellectual property and commercial litigation. Then we have Lucy, which is an experienced litigator from UK. Hi, Lucy. She handles domestic and complex multi-jurisdictional disputes. She litigates in national courts and advises clients on the strategic coordination of proceedings across UK, EU, and worldwide. And then we also have Birgit. She is an attorney at law based in Vienna, so from Austria, which is very interesting because we as German lawyers and as Austrian lawyers, we all speak the same language, but we have a different system, which is kind of similar, but which is quite different. So it's always good to have a comparison between Germany and Austria, because at first sight, we always believe it's so easy, it's the same, but it's not. I'm sure Birgit will show us that. She's specialized in IP law with a particular focus on designs, trademarks, and unfair competition. Birgit handles litigation as well as non-contentious matters and assists clients in handling large international trademark portfolios. And the three of them has asked me to inform you that they would like to answer all the questions you might have or thoughts you might have in the end of their session. And I think they will manage everything and tell you their answers if you have any questions. So have a good presentation, and the stage is yours.
Thank you so much. I'm just going to, can you hear me okay, first of all? I was just having an issue with my headphones. Okay.
Yeah,
perfect.
we can hear you.
Okay, I'm just going to share the presentation. Can everyone see that? Can you see that okay?
Yes.
And can you see the notes, or can you not see the notes?
No.
Okay, good. Great. Okay. Well,
now we can see the notes.
Oh, sorry. Okay, hold on a second. Something's gone wrong. Oh, sorry. Hold on. Okay. Is that better?
Yes.
Okay, perfect. Okay, great. Well, thank you so much for that introduction, and I'm really happy to be here today. So I think first of all, actually, I was going to pass over to Anahita. I think she was going to start.
Yeah, thank you, Lucy, and thank you for sharing your screen. So we are going to jump right in after the introduction Elisa has given us kindly. I think there's not much to add there. So yeah, we thought we would start with a high-level overview of the different legal traditions, because we are coming from different jurisdictions, but not only different jurisdictions, but with like very different legal traditions, such as common law and civil law. So we thought it might be helpful to refresh everyone's knowledge. So while it is common in common law jurisdictions, or why it is said that common law jurisdictions have an uncodified legal system and are based on case law, that does not mean that there are no or only few statutory laws, quite the contrary. But still, compared to civil law jurisdictions, the body of law in common law jurisdictions is made up of case law and legal precedents, meaning that judges create binding judicial precedents and, as such, law. They develop and create law. And yes, also in civil law jurisdictions, the courts will interpret, close gaps in statutory laws, and develop the written rules and statutes. And again, yes, also other courts, in particular lower courts, will often follow the guidance given by higher courts in prior decisions, but generally they don't have to, because in civil law jurisdictions, the body of law is made up of codified statutes and written law codes. The courts will apply the law, and every court is free in its interpretation and application of the law. And that's also why the court's role in knowing and applying the law that also leads in a different role during litigation. The judges in civil law jurisdictions actively guide the litigation and decide what facts and evidence they need and demanded. On the other hand, in the UK, solicitors are actively involved in determining what evidence is needed from the other side and also in demanding it. And as you might know, in the UK, there's also a second type of lawyer, which is the barristers, and they will present the case in front of court and, for example, also cross-examine the witnesses. So now that we have sorted the basics of the different legal traditions, I will hand over to Lucy, who will get started with the IP-specific topics.
Great. Yeah, so I think before we wanted to get into the details of the different ways that the different jurisdictions deal with evidence, we thought we should just compare and contrast a little bit at the outset the different way that IP litigation proceedings are run at a high level in the different jurisdictions. So I should say at the outset, and you may already be aware, that unlike Germany, patent litigation proceedings in the UK are not bifurcated, so validity and infringement are heard together. And I should also say, I'm obviously focusing on the UK today. I'm going to focus on the proceedings in our patents court in the High Court, which is where most of the patent litigation takes place. You may already be aware there is another court, a smaller court called the Intellectual Property Enterprise Court, or the AIPPI in the UK. That does hear some patent cases, but normally much simpler ones and much lower value ones. And the proceedings there are streamlined. So what I'm saying about evidence today probably won't apply quite as much in the AIPPI, because I'm just focusing on the patent court. So yeah, just giving an overview of proceedings. So first of all, the statements of case, or the sort of written briefs in the UK, they're really quite short. They're limited to legal arguments. They don't go into lots of detail. They're very much they're given at the very beginning of the proceedings, a long way before that the case is fully developed, but they're just limited to the very key legal arguments. And then in terms of evidence, documentary evidence is then introduced throughout the proceedings after the written brief to substantiate each party's case. So that might be by way of some documentary disclosure, that might be by way of expert reports, which are really important in patent litigation in the UK. And I'll come on to talk about those in a bit more in a bit. And also witness statements are sometimes relevant as well. And then in terms of trial, I understand this is probably quite different from Germany. In the UK, patents court trials are massive. They take a very long time. A typical one might take 5 days, but it might take up to 15 days with lots of days of cross-examining witnesses. And again, we'll go into that in a bit more detail in a minute.
I will jump in here and do the contrasting now to Austria. So I will give you a short overview of the evidentiary proceedings, particularly in Austria, and how they are introduced and how it is all started off, and which are like the most important aspects to consider. So for Austria, when it comes to IP litigation, it typically starts out with a quite comprehensive brief. This is also one difference we figured out when preparing our session to the UK, that we actually already starting with the lawsuit need to lay down all the facts of the case comprehensively, which means we start by explaining the matter that gives rise to a claim, which is then followed by the legal arguments. And in Austria, it is very common to combine a lawsuit with a PI request. So this introductory brief will already be quite comprehensive and contain all the asserted facts. All facts that are asserted in this brief then need to be backed up by some means of evidence, and this evidence already needs to be offered in the introductory brief. If there is no evidence to be, or that serves as support of the asserted facts, the court will not be able to base its decision on those facts, and that, of course, we want to avoid. So just to give you some examples for evidence when I'm speaking of that, for us, it starts out with proving the existence of the claimant and the defendant, which should normally be quite an easy task, because you would usually rely on a company register excerpt that is publicly available, so easily accessible. If you are, for example, dealing with a design infringement or a trademark infringement, you probably want to prove the availability of the infringing design item or a product packaging that probably bears a sign that could infringe a trademark. So we would normally file a website excerpt, which again would be publicly available. For example, an excerpt from an online shop where a product would be available for purchase. Or what we also like to do is test purchase. So really go to a physical shop, purchase the product there, and then we would file the invoice. Yeah, and that would also serve as evidence for the availability of the product, that it was available in Austria and at a certain point in time. And of course, what we all also come across in trademark proceedings quite a lot is the proof of reputation of a trademark. And there you can distinguish between external data and internal data. So external data would be, for example, market shares, and those data are most of the times provided by third parties. So for example, by Nielsen. And of course, if you can get hold of them, brand awareness or reputation studies that are done by market research institutes would also be external data that would be suitable evidence here. When I'm talking about internal data, I mean, for example, sales figures or also advertising figures. And maybe you also want to point to advertising examples, also including data that's really just known by people who have access to company internal documentation. So when were the advertising published and where, and also the extent of publication. And all those things can, of course, already be part of the facts laid down in the introductory brief. But we would then always offer the person to confirm this as a witness, so to offer the court to have the person as a witness testimony. The case is then predominantly decided on the basis of the facts and arguments presented by the parties in their written briefs. And only if the court finds that it cannot decide the case based just on those facts presented by the parties, it will order the production of evidence. And I will just quickly go into how this would be done. In Austria, there would be a preparatory session in front of the court that would be ahead of the actual oral hearing. And this preparatory session, the court, together with the parties and the representatives, would draw up a trial schedule, which would also contain a schedule for the taking of evidence. So the additional taking of evidence would then take place in the oral hearing, and that would usually be the witness testimony, either as applied for by the parties or by one of the party, but this can also be ordered on the court's own motion, or also expert opinions, which is, however, rather unusual in Austria, and we will go in more detail on that a little bit further. And yeah, the oral hearing, which is also quite different to the UK, in Austria is typically scheduled for some hours, I'd say. There are exemptions where the oral hearing would be scheduled for some days, but that would only really be an exemption when the judge knows that there are several witnesses to be examined. But like the standard case would be like 2 or 3 hours trial, where all the witnesses would be heard and any other evidence would be taken.
Thank you, Birgit. So I will take over from here. And as Lucy has already pointed out, in Germany, we have a bifurcated system when it comes to patent litigation, meaning that infringement cases are litigated in the civil courts, typically the regional courts in the first instance, and also meaning that the procedure mainly follows the rules of the Civil Procedure Code. And then the question of validity is litigated in a special court, the Federal Patent Court in the first instance. How to best handle evidence when litigating in the Federal Patent Court was already covered by our esteemed colleagues Rebecca Hendrich and Markus Oystermann in their morning session. So therefore I will focus on the infringement proceedings. And as Birgit also already has described, in Austria, also in Germany, the basis of the lawsuits are comprehensive written statements in which the parties will assert their facts and make their arguments. And in general, throughout the session, you will notice many similarities between Austria and Germany, but as also already hinted, there are some slight differences. And one of these differences is, for example, that the parties do not necessarily have to evidence every asserted fact. And I will go into a bit more detail what that means in a second. But before, it's also important to point out that the infringement courts have usually discretion when whether it finds necessary to take evidence or not. But the court's discretion only lasts as long as no party has made a conclusive application to the court for the taking of evidence, or when certain other requirements are given, which I will go into also in a second. The rejection of a reasoned application for taking of evidence would violate the fundamental right to be heard. And as also is very obvious when looking at the slide, there is a huge difference between the UK proceedings and German or Austrian proceedings, which is the duration of the trial. And in Germany, we have usually only one hearing date. And there is also very interesting statistics from 2021 that showed that there are on average 1.3 trial dates scheduled per per every concluded civil trial in the regional court. So this is that there's only one hearing date is not only a specificality in IP litigation, but in civil litigation in general in Germany. And that doesn't mean that the Civil Procedure Code does not allow for the possibility of multiple trial dates. There is the possibility for a court to order an advanced first hearing prior to the main hearing date. This possibility is generally used by the Munich Regional Court in patent infringement proceedings in its so-called Münchener Verfahren, which means Munich proceedings. That means the Munich Infringement Court will use an advanced first hearing date in a similar fashion as UK courts use the case management conferences, and also how Birgit has described the early hearing dates that they have in Austria. They will use this hearing date to structure the proceedings and address main issues of the case early on. And the reason why they do it is because they want to expedite infringement proceedings. And remarkably enough, the Munich Infringement Court has also published guidelines to its Munich proceedings. And in these guidelines, it has also stated that it will only, for example, take expert evidence in extraordinary cases. And from a common law lawyer's perspective in particular, this might seem interesting, to say the least. But when you consider the German law background, it becomes clearer why a German court might make such a statement. And that is what we will do now. So we will have now our first deep dive of the day in relation to the prerequisites of taking of evidence in Germany and Austria, but the Austrian part was already covered by Birgit. So we will focus here on the German part. So we already talked about that the infringement courts have discretion and that there are apparently some courts rather reluctant to take, for example, expert evidence. And also, again, the statistics show that it's not only infringement courts, but civil courts in general in Germany that have the tendency to not take evidence. So again, the statistics from 2021 showed that only 12.8% of trial dates held in German regional courts included measures of taking of evidence. The background for that is mainly the degree of convictions courts need for their decisions. In its Anastasia judgment from the 70s, the German Federal Court of Justice has laid down the basic principles of that, which is that the law does not presuppose a conviction free of all doubt. The deciding judge's own conviction is what counts, even if others have doubts or have reached a different opinion. However, the judge may and must, in case of actual doubt, be content with a degree of certainty that is useful for practical life and that silences doubt without completely excluding it. And what the effect of this definition is that because we also have the principle of submission that applies in infringement proceedings, meaning that the court makes its decision based on the facts presented by the parties without being obliged to investigate the facts of the case itself. This has the effect that the court will make its decision on sufficiently substantiated facts that have not themselves been sufficiently disputed. So to make this a bit more plastic or a bit more vivid, maybe an example will help. So for example, if you have a case where the claim construction is undisputed and you have a holder of a patent who states in his statement of claim that given the functionalities of the alleged infringer's product and the components used, the process that the alleged infringer must have implemented infringes the rights holder's patent. If the alleged infringer then goes ahead and just plainly states that it doesn't use the process described in the statements of claim, that is not enough for a court to then go ahead and take evidence. The court will then first make an indication to the alleged infringer that it doesn't think that the alleged infringer's statements or statements were substantiated, and that gives the alleged infringer the possibility to substantiate its statements. And if the alleged infringer doesn't do that, the court will just go ahead and rule in favor of the rights holder. But if the alleged infringer now goes ahead and describes how it uses maybe different components than those described by the rights holder, or that describes how the process he uses is different to the one that the rights holder described, then again the rights holder doesn't oppose anything, the court will go ahead and probably rule in favor of the alleged infringer and dismiss the claim. But if, now again, you see it's kind of a ping pong. If then the rights holder again opposes that sufficiently, and the two parties will reach a deadlock in their substantiation of their facts, the court will probably or should go ahead and order the taking of evidence if it finds that it can't base its decision on undisputed facts presented by one of the parties. So you have there the interplay between submission and counter submission, and your degree of substantiation always relies on what the opponent or the other party said. And that is basically the main reason why oftentimes there isn't evidence taken, because one of the parties might fall short or might not substantially or sufficiently substantiate their facts presented.
Thanks, Anahita. So I think now we were going to talk a bit about documentary disclosure. Now, in civil proceedings in the UK, documentary disclosure is a really common step. And this is where each party discloses to the other party documents that are in its control that are relevant to the issues of the case. So the standard order was always typically that parties would need to disclose documents on which they rely, but also any documents that they have which adversely affect their case or the other side's case. Although the court does have the discretion, and I'll come on to talk about that in a bit more detail in a minute. So this means, though, that parties do actively have to offer up for inspection any documents that they have which might be harmful for their case. They can't sort of hide things away. They have to offer them up. And that means that they can't just cherry pick and rely on those documents that they have that are helpful to their case. So parties will often be required to undertake a reasonable search for documents. And so what counts as reasonable will really depend on the number of documents involved, the nature and complexity of the proceedings, how easy it would be to retrieve them, how expensive it would be to retrieve them. However, these, as you can imagine, these disclosure exercises can be really expensive. They can take up a lot of resources and be really costly. And it can be a really enormous exercise to identify where the relevant documents are held. Sometimes there are still historically some hard copy documents, but obviously now most things are electronic documents, and it can be a really big undertaking to find out where documents are stored electronically, identify what folders they might be in, who the relevant custodians might be, if there are specific inboxes or mailboxes that need to be searched. Then the documents need to be obtained, then reviewed for relevance by outside counsel, and produced to the other side. Any material that's privileged, so it has the dominant purpose of relating to legal advice or relating to litigation that's either occurring or is contemplated, can be withheld from disclosure. But in order to work out whether things are privileged, you normally have to do quite an extensive privilege review, and that as well takes time. So for all of those reasons, there has been a recent move in the UK towards a more streamlined disclosure process. Sometimes the court, although there was historically the standard order, sometimes the courts now might just make an order for disclosure for specific categories of documents or for particular topics on certain certain categories of documents, just disclosure on particular topics or issues, or even sometimes no disclosure at all. And in patents cases, specifically in the UK, there are the rules which say that in certain circumstances, there won't be any documentary disclosure. I'm going to talk about that. I'll go into that in a bit more detail in a minute, but I was just going to pass on over to, I think, Anahita here to talk about the position from Germany.
Yeah, thank you, Lucy. So also in Germany, documentary disclosure has not a lot of relevance. However, it is usual that parties will submit documents as annexes to their written submissions, but these annexes will not constitute documentary evidence, but rather serve to substantiate the facts presented by the respective party and will be treated as statements of case. And when it comes to adverse documents, in Germany, there's a general rule, or the prevailing principle is that nobody is obliged to hand over their weapons to their opponent. But in the interest, so to say, then of equality of arms, there are situations in which one party can apply that the opposing party should disclose adverse documents. And when we look at documentary evidence, one of these exceptional rules is Section 421 of the German Civil Procedure Code, whereby a party can offer evidence by applying to the court that it should order the opponent to produce a record or document of which the party tendering the evidence alleges to be in the hands of the opponent. But this, as you see, or as you see, requires that the party applying already knows what documents it is looking for. So there is no such thing as a fishing expedition, or usually also not that you can just basically state into the blue that there should be documents that the other party has to disclose. And then pre-infringement cases, there's another exception or a specific situation, because in implementation of Articles 6 and 7 of the Enforcement Directive, the German legislator implemented rules which allows the rights holders to request the production of documents or the inspection of an object in the possession of the alleged infringer if it's necessary to substantiate their claims. So that is another specific situation where in Germany you can ask for the opposing party to disclose adverse documents.
Thanks, Anahita. So I was just now going to talk about these exceptions in patent litigation in particular. So in patent litigation, there's no documentary disclosure required in certain cases. So one is if infringement is an issue, provided the alleged infringer provides what's called a product or process description, or a PPD, then they don't need to provide disclosure in relation to their product or process. And a PPD is basically, it's described as full particulars of their product or process that's alleged to infringe, including drawings or figures if necessary. These are often highly technical documents that can go to a number of pages. And so the way that I think the theory behind it is the patentee has got the primary responsibility to articulate their infringement claims as clearly as possible. And then it's for the defendant to provide full details of their product or process. In terms of how specific those details need to be, the idea is that they need to be have at least the same specificity of the patent claims, but sometimes they need a bit more, just to make sure that everyone in the court and the parties can fully understand and fully assess whether the product or process infringes. Now, obviously, you can see alleged infringers in this case, if they're the ones that have been sued, there is a real reluctance where they think, why should I hand over all of this information that can be highly confidential and sometimes can really relate to highly commercial sort of trade secrets. So normally what happens is it's possible to impose a confidentiality regime. So the other side would be given access to that confidential information in exchange for providing undertakings on the use of that information, so that they won't use that information for anything other than these proceedings and that kind of thing. Sometimes, though, if the information is really highly commercially sensitive, or, for example, the other party is a direct competitor, and the alleged infringer really doesn't want and can make good arguments as to why the specific commercial people from the other side shouldn't see this information, the UK courts are prepared to enter into and to put in place what we call confidentiality clubs or confidentiality rings, which have different layers of confidentiality restrictions. So they might order a confidentiality club that's called lawyers' eyes only. So no one from the commercial side can see this, but only lawyers can see it. So external lawyers and also any in-house counsel, or it might be, if it's really sensitive, external eyes only, so that no one from the client can actually see it at all, and just the lawyers. If a product and process description is provided, the defendant still might have to provide some disclosure in relation to any alleged infringing acts that they have been alleged to have undertaken, but they won't need to provide anything further in relation to their actual product or process. So then turning to validity, no disclosure is required if validity is an issue, apart from documents starting 2 years before the earliest priority date and 2 years after, which is known as the 4-year window. Now, even though that's often the general rule, the Patents Court, especially more recently, is tending to be pretty strict about disclosure in patent validity cases, particularly in the case of obviousness. And I think that's because when they're considering whether to order disclosure, because it can be so expensive and costly and use up so many resources, as I explained earlier, the court has to consider whether ordering disclosure is really consistent with the overriding objective, which is one of the main principles of the UK court system, the English and Welsh court system, which is to enable the court to deal with cases justly, but also at proportionate cost. So the two things they'll really consider are, what is the likely probative value of any of the material that they're actually going to get? And also, what is the cost of this procedure going to be when taken into account of the context of the proceedings as a whole? So if it's a very large, very expensive case with a lot at stake, they might be more willing to order disclosure, but if it's quite a small case, they might not. Particularly in the case of obviousness, they are much more reluctant to order disclosure, and that's because obviousness or inventive step is really seen as an objective question. Assessing the person skilled in the art, they're a legal construct. There's not going to be any real person that is the same as that notional person skilled in the art. So the thinking behind it is there's evidence of what the inventor actually did, or steps that they took, or what they knew, is not really going to be of value, particularly in relation to obviousness or inventive step. In those cases, the primary evidence of value is going to be from a suitably qualified expert witness, which we'll come on to. The courts, they will sometimes more readily order sufficiency disclosure, and that's because it can be powerful evidence in support of insufficiency if the patentee's own documents show that despite serious efforts to do something, they were unable to work the claimed invention either at all or in some material respect. The other category where they won't tend to order documentary disclosure is documents which relate to commercial success. And rather than their ordering disclosure of documents, instead the patentee might instead, or normally instead, serves a schedule which identifies the patented product or process, any related revenue, and any relevant dates. As I said there on the slide, duty of disclosure is continuing. So what that means is if disclosure is ordered, then it's not just that the documents are provided at one date, and then if anything comes to light after that, you can hold it back. You have to just continue to disclose right up until the trial date. And one other type of, which isn't really documentary disclosure, but one other type of evidence that I thought would be worth mentioning here for patent litigation are experiments. So this happens quite a bit. If a party is seeking to establish any fact by experimental proof, they have to serve a notice of experiments on the other party. And then that other party has the opportunity to inspect a repetition of all or a number of the experiments. And the idea behind that is so parties can't just cherry pick experiments that work or that suit them. It has to be an objective experiment. They have to lay down all the different criteria and the conditions of that experiment, and then the other side has to come and inspect that. And some of the most fun experiences that me and some of my colleagues have had are going along to sort of factories to witness experiments. They're always quite fun, and there's always quite a lot of pressure, obviously, at the moment to see whether the experiment does what the party wants it to do at the time. But anyway, so I think that was all I was going to say on this. Let me pass over.
Yeah, thank you, Lucy. That was very interesting. And also on the point of the experiments, has it happened often that the experiment didn't work when you were there to examine it?
I haven't personally seen that happen, but it does happen more often than you think. So we often actually, I mean, it obviously depends on the case, but I think we don't advise clients to rush to introduce experiments because they can be very complicated. We often think if there is another way to prove something without reverting to an experiment which the other side can witness, then in some cases that can be more advisable. And at least more relaxing for everyone.
Yeah, I would assume so. Yeah, so my next deep dive slide goes in the direction of not maybe experiments, but the possibility for the rights holder to go and examine the product of the alleged infringer or its production site. And as already hinted earlier, this sort of rule was implemented against the backdrop of Article 6 and 7 of the Enforcement Directive, which is an EU directive, and I believe has been or should have been at least similarly implemented in Austria. And I guess there was no direct implementation necessary in the UK, as their evidence system is already also, from what you already described, Lucy, very similar to the stipulations in the enforcement or in this regard of the enforcement directive. So in Germany, there has been an implementation, and I will focus on 140C German Patent Act, which relates to its implementation in relation to patent litigation. But there are also similar stipulations in other statutes in Germany. For example, in the German Trademark Act, you would find something similar. So what does Section 140C German Patent Act provide? It provides that the holder of a right may request the production of documents or inspection of an object in possession of the alleged infringer if it is sufficiently probable that the patent has been infringed and if this is necessary for the rights holder to substantiate his claim. So what does sufficiently probable mean? Sufficient probability means that it may be uncertain whether there is an infringement of rights, but there must be concrete evidence that suggests that the possibility of an infringement of rights is happening with a certain degree of probability. But this only applies to the facts that are to be clarified by the requested inspection. For facts independent of the inspection, these must be proven or made credible. For example, the active legitimation of the claimant. So, and what does necessity mean? Necessity mean like necessity is not given if the claimant at the same time has other simpler options for clarifying their claim or for providing evidence, which are objectively equally suitable as the measures described in Section 140C, and which the claimant can reasonably be expected to accept according to his personal circumstances. One example for this is if you have, for example, a product which is very expensive to purchase, it might be not reasonable for the rights holder to expect to purchase that product, or if you can only purchase the product with typing or giving away who you are. But on the other hand, if it's very easy to get access to the products, you of course are required to first resort to that before you apply for the inspection of an object. And how do you like in a procedural way, get to use that right that is granted to the rights holder in Section 140C? That is usually done by first granting or first pursuing an independent evidence proceedings because in Germany, before you start your main trial, or before you start your main trial, you can enter into independent evidence proceedings, and that is if you want to substantiate your claim. Of course, if you want to use this mechanism to substantiate your claim, it of course makes sense to pursue the independent evidence proceedings before you start your main proceedings, to go and have an inspection of the production site, for example, of the alleged infringer. And then simultaneously to that, the court will also order the alleged infringer to tolerate the rights holder to come and inspect the object in possession of the alleged infringer. But because the German Patent Act in paragraph 3 of section 140C provides that the secrecy and confidentiality interests of the alleged infringers are respected, usually it is not ordered that the alleged infringer has to tolerate the rights holder himself to be present, for example, at the production site of the alleged infringer, but usually the legal representatives or like the lawyers of the rights holder and a court-appointed expert, and the court-appointed expert will then produce an expert report about the findings they had when inspecting the object or the production site. So there you can see again some similarities to what you have already described to us, Lucy. For example, when it comes to that only lawyers are allowed to see certain documents produced by the alleged infringer. And yeah, so after that, after the expert has produced its expert report, usually the usual way that things would go ahead in independent evidence proceedings would be that the applicant, so in IP cases the rights holder, would be handed that expert report. But of course, again, with thinking of the secrecy or confidentiality interests of the alleged infringer, the alleged infringer can, in the cases of section 140C, apply to the court that the expert report isn't given to the alleged to the rights holder without any further stipulations. Then again, you could, for example, order for only the lawyers to see that expert report or only the court to see that expert report. So yes, so there are also measures to ensure the protection of confidential information in German IP proceedings, and also in infringement proceedings. There are extra ways to get to information that are maybe not available to that extent in other civil proceedings in Germany. And I think with that we can go ahead.
Great, thank you. So I was now going to talk about some expert evidence. So focusing on patent litigation in the UK, expert witnesses play a really significant role in patent litigation. They give the primary evidence regarding validity. And typically each party will appoint their own expert. However, the duty of the expert is to the courts. It's not to the party who instructed them. So the expert's primary function is seen as educating the court in the technology. And the expert will be from a specified technical field which relates to the invention. Sometimes, though, it's really common actually that you end up with multiple experts in one patent case. So, for example, in pharmaceutical patent cases, which I've worked on, there might be any of a medicinal chemist expert, a pharmacokineticist expert, a formulator, and or a clinician. You might have 2 of those, 3 of those. The expert will typically give evidence on the common general knowledge, or the CGK, at a relevant date. And they'll also give evidence that's related to the questions of novelty or inventive step or sufficiency, depending on what's in play in each case. Although obviously the court will come to a conclusion on those as a question of law. It's not for the expert to give their views on whether the patent is novel, but they'll be able to give, the invention is novel, but they'll be able to give their expert opinion of the issues surrounding the specific technology. So instructing experts, obviously, it can be quite, it's really, really important, because even though each party does appoint their own expert, as I've said, the duty of the experts is to the court. They're meant to be impartial. And we have been given lots of judicial, as UK litigators, we've been given lots of judicial guidance on how to instruct experts. So we're told we have to keep the experts' need to remain objective at the forefront of their minds, at our minds. And one of the things we have to do is called sequential unmasking. And what that means is when we instruct an expert or work with an expert, there is a specific order that we have to deal with things with the expert, and an order in which we have to discuss documents to avoid hindsight or any allegations of hindsight. So firstly, we would discuss the common general knowledge with the expert, take a very detailed note of what they have to say. Then we'd show them any prior art documents and then take a note. Then, to the extent relevant, the priority document and the application is filed. And only once they've given us their impartial view on all of those do we show them the patent. So the idea there is that you're trying not to sort of infect the expert's opinion on any of those previous things, like the common general knowledge or the prior art, by what's in the patent. They're meant to sort of do it in that order first. Clearly, these things sometimes can go wrong, and there have been many cases where lawyers have been heavily criticised by the court or the judge at the time for instructing their experts in the wrong way, or being overly restrictive about their evidence, or asking them the wrong types of questions. So it's something that we have to be very careful at, is to make sure that the expert is instructed in the right way, particularly because the expert evidence is the most important evidence normally in a patents case.
I think that's very, very interesting that expert opinions are so important and of such huge relevance in UK IP proceedings, because in Austria, and as I understand also in Germany, that's quite different. For us, it's rather unusual that in IP litigation in Austria, experts are ordered by judges. My personal opinion is that I think this is due to the fact that involving an expert, this would just make the entire proceedings more lengthy, and judges normally would like to avoid that. And also, of course, high costs are involved, because in Austria, the judge would normally order the applicant party to make an advance payment, which can be up to several 10,000 euros. So I think that's why judges usually shy away from ordering experts. However, I am currently involved in an unfair competition proceeding where the judge has now appointed an expert. So that's quite interesting also to see that. I think also a main difference is that in Austria, the judge appoints the expert, and the judge then also controls the whole appointment process. So in Austria, we have a list of authorized and certified court experts with professional qualification. This is a list of several different experts. They're categorized according to their specific expertise. And from that list, experts can be chosen. This list, however, is only a recommendation. In general, also other experts could be appointed as experts in the proceeding. The court normally also asks the parties in advance to submit proposals for potential experts. We would then submit our proposals to the court, and the court ultimately decides whom to appoint. And the parties still can reject the appointed expert for the same reason as a judge could be rejected due to concerns about bias, for example. And the expert, the role the expert would take in Austrian proceedings is that the expert would deemed to assist the court in providing knowledge and specific expertise the judge cannot possess. So that's, as I understand, quite similar to the UK. And that was also the point where the expert came in our pending case, because the case is about whether a rubber compound is compliant with an European standard. And this question is actually highly technical and cannot really be answered by the court itself, because essentially what needs to be done is that the rubber compound needs to be examined and tested, and then the conclusions need to be drawn whether the compound actually fulfills all the requirements that are set out in the standard. So this is now been done by an expert, and yeah, we're still waiting to learn about the expert's opinion. Also, there's a really interesting difference between the court-appointed experts, and also we have the possibility to file private expert reports in Austria. Only court-appointed experts can actually provide expert evidence. Parties can, however, independently commission expert opinions, which then would be private expert reports, and they merely prove the view of the author. So the court would be in no way bound in that regard. So that would qualify, as I think is the same in Germany, as a qualified factual statement by the respective party. And ultimately, the court decides which facts relevant to the case should be addressed by the expert. So in our case, the court asked both parties in advance to submit a list of proposed questions, and the court then consolidates an ultimate list of questions based on the lists of questions by both the claimant and the defendant. And this list of questions by the court is then posed to the experts, and those questions need to be addressed in the expert report. And one final interesting fact, there's no direct contact between the expert and the parties or the parties' representatives, to simply ensure that the expert's independent and also unbiased.
Thank you, Birgit. And I think from the German side, there's not that much more to add to the expert evidence and how it's taken. Maybe just to tie it back into like the whole theme here from the German side, that evidence is not taken that regularly. Because, for example, when you now look at the point of expert evidence, you can, if there is a undisputed claim construction the court can, for example, base its decision on, it doesn't need to take expert evidence. And only if, for example, if the claim construction is in dispute, or if there are facts following from that are in dispute and can't be solved by taking on some statements that are undisputed, the court will go ahead and take evidence. And as a rights holder, if you found or if you are able to find a way to present an undisputed, for example, an undisputed claim construction on which you can base your claims, you would rarely have interest also in involving an expert, because that will elongate the duration of the trial. But if you're an alleged infringer, and if you know that the patent might expire soon, that may be in your interest to prolong the litigation. So when you keep that in mind, you can maybe also play with the involvement of expert evidence. And in the interest of time, I think we should go ahead.
Yeah, exactly. I've just realized the time. So
yeah.
I thought we could very briefly, just to close out the expert evidence point. Expert evidence from the UK is, the main source is the written expert report to start with, but the expert will be cross-examined at trial, and that will be very extensive cross-examination. Often it might only be, well, it might be 30 minutes to an hour, it might be a day, or it might be more than a day. And it's all normally by the other party's barrister rather than the court. And I think it's it's often the court that asks the questions, isn't it, in Germany and Austria.
Yeah. Yeah, maybe we want to end the session with quickly looking at how you can use this evidence. Yeah, that's what I meant. The evidence produced in the UK in foreign proceedings.
Fine, we'll try and keep this really short. Basically, because as we've talked about in terms of disclosure being a big thing, or can be a big thing in UK proceedings, one of the questions we often get from lawyers who are doing parallel proceedings, maybe in other jurisdictions, is, can we use the document? Wow, you've got some documents in the UK, can we use them elsewhere? And the answer is no. To start with, you often can't. That documents that are disclosed in UK proceedings can normally only be used for the purpose of the action in which they've been disclosed, except once they've been referred to in court. So once they've been referred to at trial, then they can be used. Sometimes if the court gives permission, or if the other side agrees, then they can be used. Typically, though, as we've talked about, a lot of these documents can be highly confidential. So the court, even after a trial, may give an order to make sure that the document stays confidential. And we've had a couple of cases where the court refused JC Bamford and Manitou, the patentee asked if they could use what the defendant had disclosed about their product or their process in their TPD, asked the court if they could go and then use that in parallel proceedings in Europe. And the court said no. We've also had another case various cases where a party has applied to the court to ask if they can use documents in parallel EPO proceedings, and the court has said no. It is sometimes possible, but there are restrictions. And if you were to go and use documents which haven't been, you haven't got the approval of the court, then that can sometimes be contempt of court. So that can be quite serious.
Yeah, thank you, Lucy. And maybe just one point to whether you can use, from a German perspective, use those documents produced abroad in Germany. That is quite a nuanced. There is a quite nuanced answer to that. But for example, when you look at the stipulation in the US with the 28 USC section 1782, where you can access pre-trial discovery in the US if you have one of the parties, or if you have, for example, the alleged infringer being a US company. The prevailing opinion in Germany is that you should be allowed to directly access that mechanism in the US, and then to also use the evidence or discovered there in German proceedings. But that is just now a very short answer. Of course, there are more nuances to that, and that is maybe something we should keep in mind, that this was now a more, just in the sense of time, I wanted to give an answer to that too. So thank you everyone for your attention.
Okay, thank you very much. Your last point was quite interesting, and we were discussing internally, Nicholas and I, about this point. What do you think? Maybe we still have this time. Maybe you can answer it anyway. What do you think? Is it, or what types of evidence would you recommend to bring from a UK proceeding into a German or Austrian proceeding, or vice versa? Can you specify, because we're talking about Ordre Public and all this stuff, but do you have any experience when it comes to that question, or what are your thoughts on that?
I mean, I think one of the things that parties often want to do is what they asked to do in the case I just mentioned there, which is to use, for a patentee to use information that an alleged infringer has disclosed about their product and process. Often it just depends on what agreement the court has come to about how confidential the document is, and it really also depends on timing. So if you're in a scenario where the UK litigation has gone first, which sometimes happens, and then you've got the parallel proceedings later, then it may be easy, so that depending on how confidential the information is, but anything that is public and not confidential, once the trial has happened, it's easy to go ahead and then use those documents. So I have had scenarios in practice where people sue in the UK first, thinking, well, at least we can get some disclosure in the UK, and then we can then go on and maybe use it in other proceedings later. So sometimes timing can be really important.
Mm-hmm. Yeah, because there's a big difference, right, between our systems when it comes to the documentation shown. So I think this is quite an interesting approach, which could be followed in order to gain some information whether it's worthy to continue with proceedings, right?
Yeah, I guess the warning point to that is, as those cases I mentioned show, is the court won't always let you, and especially if they're things, even if they've been referred to in court, if it is something that's highly confidential, just because you've got parallel proceedings, you won't be able to get around the confidentiality restrictions often. I mean, you can always write to the other side and say, I know you said this was confidential, but are you willing for us to show it? But most times, obviously, they'll say no. But you can always ask.
Okay. Okay, so thank you very much. I wanted to tell the audience that if any question comes up now during the break or maybe in the next days, you can always get in touch with us, either directly with the speakers or I believe also via the AIPPI events team. So we will get to know what your questions and thoughts are, and feel free to contact us. I think we're happy, and especially the speakers are happy to continue the discussion that we're having with these presentation and topics. So I think if you don't have anything to add, I would suggest to start our lunch break, and would ask everyone that's interested to come back to session 4 at 2:15. Session 4 will be about the UPC. We all have heard a lot about the UPC in the last months. But this is a very interesting approach. The session is called Perspectives on the UPCA, Comparison of the Agreement and ROPs, the German, Italian, and French National Procedure. So we will have speakers from all these different jurisdictions sharing their impressions. And then I will also hand over to Nicholas, my colleague that was talking this morning, concerning the moderation. So thank you everyone for participating, for being here, and I hope to see you in the afternoon. Have a good lunch, and yeah, see you later.
Good afternoon everyone, and welcome back to session 4 of our webinar. So the topic of session 4 is Perspectives on the UPCA, Comparison of the Agreement and Rules of Procedure to the German, Italian, and French National Procedure. And for those who have not attended the webinar in the morning, my name is Niklas Geig. I'm a patent litigator at NER in Munich, young member advisor to the German National Group of AIPPI, and I will be moderating this session. Please welcome with me our speakers Magali Contardi, Carsten Plaga, Karl Alexander Dinges, Alessandro Burra, and Collard de Vinon. Overall, we have 3 AIPPI national groups represented in this session. And those are the Italian, French, and German National Group. And our speakers will be from the German group, Carsten Plaga, who is a senior associate at German boutique law firm Carter Augenstein in Düsseldorf, where he started his career as an associate in 2018. Carsten's current practice focuses on patent litigation in fields such as medical devices, consumer electronics, and telecommunications, including multinational litigation. And our second speaker from the German group is Karl Alexander Dinges, who is a German attorney at law, certified IP lawyer and UPC representative working at law firm Preu-Bohlig in Düsseldorf. Karl Alexander has been practicing law since 2017 and focuses on patent and trade secret litigation. And he advises clients inter alia in the pharmaceutical and telecommunications sectors. Next, from the Italian group, we have Magali Contardi, who is an Italian lawyer and IP researcher focusing inter alia on the judicial and extrajudicial protection of IPR rights and on helping companies identify, protect, and exploit their IP assets across a wide spectrum of industries and areas. Before founding her own firm, Contardi IP Law, she worked in IP firms in Germany and Italy and had legal roles both at the EPO and EU IPO. And our second speaker from the Italian national group is Alessandro Burra. He is an Italian attorney at law with a focus on the enforcement of patent, design, and trademark infringement, especially in medical devices and fashion industry sectors. And he's also experienced in the fields of patents, utility models, know-how, and unfair competition. And he provides legal services also when it comes to copyright software and privacy disputes. And last but not least, from the French national group, we have Collard de Vinon, who is a French attorney at Jones Day in Paris. He worked on patent matters both in France and abroad, including Germany, US, and the UK, for startups as well as for international companies. And Colin's primary focus is on patent validity and infringement litigation, including employee inventions and patent ownership claims. And he also regularly drafts and negotiates confidentiality license, research and technology transfer agreements, and also performs IP due diligence in support of M&A and private equity deals. And now, without further ado, let me hand over to the speakers themselves. And let me say I'm looking very much forward to your session.
Niklas, thank you very much for your kind introduction. Hopefully you can see the first slides. Today we want to talk about how to handle evidence before the UPC in the light of the German, Italian, and French perspective. The UPC includes at the moment 17 member states which have ratified the UPCA and 7 member states which may follow in the next couple of years. In these member states, we have completely different national procedural law in regard to handling patent infringement cases. These different systems clash in front of the UPC. Therefore, we want to take a look on the key difference between the German, Italian, and French system in comparison to the agreement and the rules of procedure of the UPC. In addition, we will take this German, Italian, and French perspective to interpret the agreement as well as the rules of procedure and to get a better understanding how evidence will work before the divisions of the different member states. For this, we of course take a quick look on the first decisions of the local divisions and the first decision of the appeal court. Here we will ask whether the different systems of procedural law influences in particular the local divisions and will maybe lead to different case law in the different member states in the first years of the UPC. Furthermore, we have to ask us in which direction the appeal court will develop the rules of procedure to balance the influences by the different systems. To get answers on these questions, we have structured the section as follows. So we will start with the general question, who has to offer evidence, who has to provide evidence to the court for what statement of facts at what time? Does the plaintiff have to submit all evidence together with the statement of claims so that the proceedings are very front-loaded? Or does the plaintiff have the possibility to submit evidence at a later stage of the proceedings? We will then talk about various means of evidence. This is not only about the means of evidence themselves, but also about the possibilities of gathering further evidence or preserving evidence that is not available to the plaintiff at the moment. In this session, we will focus on the most relevant means of evidence before the UPC. Witnesses and experts as means of evidence, as well as a Caesarean inspection as opportunities to preserve or gather further evidence. If we have enough time at the end of our part, we'll take a look at 2 further topics that are related to our main topics: access to the register and therefore to all of the evidence in the case, and the possibility to protecting confidential information, both under the heading miscellaneous. We will start with our first topic, offering of evidence. According to Article 54 UPC agreement, the burden of proof of facts be on the party relying on facts. That is the principle. For example, the plaintiff must prove that the product makes use of the subject matter of its patent. There's only one exception. In Article 55 UPC, if the subject matter of a patent is a process obtaining a new product, the identical product, when produced without the content of the patent proprietor, shall in absence of proof to the contrary be deemed to have been obtained by the patent process. The rules of procedure differ between offering of evidence and providing of evidence. According to Rule 171.1 Rules of Procedure, a party making a statement of fact that is contested or likely to be contested by the other party shall indicate the means of evidence to prove it. As we have already highlighted, whether the party has to offer the means of evidence depends on the question whether the statement of facts is contested or likely to be contested by the other party. While it is easy to determine whether a statement of fact has been contested by the other party, it is questionable when a statement of facts is likely to be contested. As an example, in an infringement action, the plaintiff should only rely on the facts that he or she believes to be true, so that they should not dispute it. But according to Rule 13.2m Rules of Procedure of the Rules of Procedure, the statement of claim shall contain the evidence relied on Rule 117.1 Rules of Procedure where available and an indication of any further evidence which will be offered in support. So it remains unclear to me which statement of facts party must exactly prove without knowing whether the opponent will contest it. At the moment, we can say with certainty is that the party has to indicate the means of evidence, not for statement of facts for which the party assumes that these will remain uncontested, but he has to indicate the means of evidence for statement of facts which the party consider will be contested. The party should offer in these cases means of evidence as soon as possible to be on the safe side. The same applies for producing evidence according to Rule 170.1 Rules of Procedure. Evidence available to a party regarding a statement of fact that is contested or likely to be contested by the other party must be produced by the party making the statement. It can be seen from both rules, 171 and 172, that the decisive factor is whether the other party contested a statement of fact. Rule 171.2 of the Rules of Procedure is somewhat more specific in this regard. Rule 171.2 Rules of Procedure, there's rules that a statement of fact that is not specifically contested by any party shall be held to be true as between the parties. But what does it mean to be specifically contested? It also remains unclear how high the hurdle is for contesting a statement of fact. So, more questions than answers. Karl, where are the differences to the German system, and can you help me to answer my questions?
Yes, thank you very much, Carsten. And also thank you, Niklas, for the kind introduction. Now we had quite a lot of interesting discussions in the last days. And I want to shortly refer to that because my impression coming from this discussion internally with Alessandra and Magali and also with Colin was that there are very, in some regard, very substantial differences in the national jurisdictions and in the views of the national jurisdictions, and the rules of procedure of the UPC and the framework you have just presented, Carsten, is somewhat a mix of these jurisdictions. And yes, I have the impression that it can also be seen and is reflected in the first decisions coming from different national jurisdictions, that each local division takes the point of view of their national jurisdiction. when interpreting the rules. And that's why it was very interesting and informative for me to get to know some aspects of the Italian law and some aspects of the French law in the last days. And I hope that we can bring this as well to the audience. With regard to the offering of evidence, I would say there are two main differences if I compare simply the framework of the UPC with the German framework. One major difference refers to with a rule which you have not displayed on the screen so far, but which is a rule that is, in my opinion, quite important for means of evidence, which is Rule 13, letter M in the UPC framework, saying that evidence needs to be filed already with a complaint. So it is a reference to Rule 170.1 and says you need to file the evidence as far as available, and you need to indicate which evidence you want to further present. And already in this regard, there is no comparable rule in Germany. So we have a comparable rule dealing with the content of a complaint, which is section 253 of the German Code of Civil Procedure. But the requirement to file a complaint does not include the requirement to file evidence. And there is case law of the Federal Constitutional Court saying that a party cannot be punished for late filing of evidence when they did not include the evidence in the complaint. So this is one major difference to note. Of course, we have a framework for late filing, but the punishment of late filing always requires that you missed a term to produce evidence after it was indicated to the party that evidence should be filed on a certain aspect. So this is the one major difference, and the second major difference is not addressing the aspect of who should file evidence, but rather the aspect of how the other party should handle with the facts provided by the first party, because in our German framework there is a burden to comment on the facts of the other party, which is laid down quite in detail in the German rules, and it basically has 4 aspects, saying both parties have the obligation to make a truth and complete statement on the facts of the case. Second, both parties have the obligation to comment on all facts of the other party. And it further says, as a third aspect, facts that are not explicitly contested are held to be true. So this is, I would say, this is reflected in the UPC agreement as well. But then it further specifies in which cases you can simply contest a fact without a full statement, pleading ignorance on the one hand, and in which cases you cannot simply do that, but need to contest a fact with a certain counter statement, which again needs to be the truth and a complete statement. So answering your question, trying to answer your question, what does specifically contesting mean? We can observe at this point that the UPC agreement and the rules of procedure do not contain a strict obligation to further specify the facts if you want to contest the fact. Of course, being on the defendant side or the plaintiff side, I would always tend to go a safe way and to not only plead with ignorance, but also to present some counterfacts, which is in order to reduce risk. But we cannot say if the UPC agreement in this regard is a little broader when it comes to contesting of facts. And going back to the German framework, what does it mean in practice that we do not have to file evidence right from the scratch? So first of all, it gives quite a lot of room for any tactical considerations when you want to file evidence. So that could be, for example, the question of whether you want to hold back evidence for some procedural benefit in order to serve a complaint to a country which is not under the Hague Convention, because you want to try to avoid a lot of translation of documents. This could be one reason, but another reason could also be tactical considerations when it comes to the overall case strategy. And to give one example, if you have a claim construction which can you have a patent claim which can either be construed in a very broad way or in a very narrow way, and if you construe it in the narrow way, you might need to rely on technical analysis and further evidence in order to show that the attacked embodiment also meets the requirement under the very narrow claim construction. It could be quite beneficial to not file this evidence right from the scratch, but only have the evidence filed which meets the requirement of the broad claim construction, because you want to avoid that in a psychological way you give a hint that the claim can be construed in a narrower way. So I have a certain example in mind. So if you have a claim with a two-layer structure, and one of the layers requires a hard material and one of the layers requires a soft material, and there's for example, you have in the description of the patent, you find hints that the technical benefit is already achieved if there's only a relative difference in the hardness of the two layers. This could be the very broad claim construction, which only requires to show, okay, there are two layers which have a different hardness, and there can also be a hint which Rockwell hardness is an example for a hard layer, and which Rockwell hardness is an example for a soft layer. And if you want to meet these requirements, you need to present further evidence. So yes, I would say it gives quite a lot of room to hold back evidence from the scratch. And I would also say from the German perspective that the level of evidence which is required in general is rather low. So I would not need to provide proof for anything that happened in the case. For example, I would not need to provide proof that I actually bought the infringing product, as long as it is clear and cannot be disputed that I have a copy of the infringing product, or I have photos of the infringing product. So the requirement to present proof for certain facts is, in my opinion, rather low in Germany compared to what I have heard so far from the other jurisdictions. But maybe Alessandro, you can comment on that, how the requirements are in Italy.
Yeah, thanks, Carl, and thanks the German group for inviting us as the Italian young AIPPI members. So it's great to discuss with you guys and all the audience in attendance about these issues that are just come up, and they are so new that we can just discuss and try to focus on how different jurisdictions are trying to solve, as Carsten said, the question posed by the UPCA. In relation to the burden of proof and offering of evidence, maybe Magali then can just provide a global scenario, but it's just a quick overview for the Italian perspective is that we cannot rely on statement between parties, as the UPC says, and also, as Carl said, under the German perspective, since the Italian regulation and the jurisdiction is based on evidence, and especially when you are asking for urgent proceedings, ex parte proceedings, you have to put everything you had on the table of the judge in order to have the description order or the seizure granted. This is actually a peculiarity of the Italian system in the sense that usually the judges are not technical, and this is why, especially in patent proceedings, they are very happy to receive, for example, a technical report from a party expert who is actually stating how the patent is constructed, how the patent in the scope of protections, and how the patent is infringed by the opposing party's product. In Italy, as I said, we cannot rely on statements. We need just to rely on evidence that we have in order to have these ex parte orders. This is why the burden of proof and the offering of evidence for the plaintiff, for the parties requesting the urgent measure, is quite high in respect to what Carl says. In this sense, also, we usually have to, when it's possible, to provide the court with a copy of the product, which is also available on the market, for example, when you are requesting a seizure, and we will see later on during the discussion. But as a highlight, we need also to provide the judge with the actual products which is allegedly infringing the patent owner. So this is why it is quite different, the Italian perspective to the German ones. It's also true that we have to rely on statement, and in part we cannot rely on that, but mainly we need to focus on the documents and also the parts and the evidence that we are offering to the judge in order to convince him to grant the measure ex parte. This is why usually in Italian proceedings, we need to file everything that we have at a very early stage without having any technical or tactical views in order to have the description order or the seizure granted as soon as we can. I don't know whether Magali wants to add something, since I saw the global scenario for the Italian perspective.
Thank you very much, Alessandro and Carl, and thank you very much, Niklas, for the kind introduction before. I think that, Alessandro, you are quite exhaustive on the answer. Actually, it is true. It's kind of an incognito, I would say, on how or what does this principle mean? Consent means, because I mean, although it sounds very similar, let's say, to the Italian situation in everyone that has, it's affirming a fact, which it's in support, let's say, of the claim that you are raising or defending. You need to submit a specific proof. But it depends, at least in Italy, on who let's say, the burden of proof lies. And we cannot really, and this is what we discuss in between, let's say, our internal discussion. You cannot really rely on the statements. You have, of course, the burden, let's say, to contest, but you cannot just simply reject, let's say, the other party's statement without submitting any proof. And this is something that it really depends also on the type of proceedings. For instance, as we maybe discuss a little later on the description, and also as Alessandro said, the description, which is the preservation of order for us. I mean, it's not enough, as in our internal discussion that we said, okay, we have this title and it has been, it's valid because it has been, I mean, you will need to submit a little more consistent proof of that, either, as Alessandro said, some technical documentation, opinion. It could be also, I don't know, the analysis that had been done, let's say, in another proceeding, or even the rejection of an opposition in the EPO, that, okay, maybe this is a little connected, as in Italy, until some years, we didn't have any substantive, let's say, analysis on patents. This is why, I mean, the title per se, it wouldn't be enough. And another interesting question is, how is this going to be interpreted by the UPC? Because at least, and so far we have seen in the 2 or 3, let's say, preservation of order proceedings that we had, of course, as these were to be followed, let's say, in the Italian territory, basically the local division decided to apply or was applicable Italian law. So it's very likely, I would say, that that these particularities that we have are going to be high consistency in the at least in the local division.
Okay, thank you very much, Magali, Alessandro, and Karl. Colin, I think the French procedural law is also different to the German procedural law. So I'm very interested for which statement of facts party has to offer and provide evidence in France.
Absolutely, Carsten. Thank you. Maybe if you can switch to the next slide,
yes.
Please. Awesome. And just before delving into the French regime, I just want to briefly comment on the previous statements of my colleagues, with which I fully agree. First, regarding Rule 13, which I do agree with you, Carl Alexander, it's a very relevant provision. And it's actually quite strange when you look at it the first time, because it says that you have to provide in the initial statement of claims both the evidence on which you're relying on for your claims, but also an indication of any further evidence that you will adduce in the future. And Rule 13 says that the party shall provide, so it's a real obligation. When you look at it, it's very counterintuitive, because obviously you cannot know in advance what evidence you will rely on before you actually get that piece of evidence. So instead, if the way to read this provision is to say you have to just put a blanket statement saying, and by the way, I reserve the right to adduce such and such pieces of evidence, that would be a very empty provision. So I do not think that will be applied exactly in this way. So yeah, a very strange provision. We'll see how the UPC court and local divisions will apply that. So far, I haven't seen any case law that gives us an indication at how the UPC will assess this threshold of, from the get-go, providing evidence and then indication of further evidence to be adduced. If it's any indication, and we'll see that later, in the first saisie order issued by the Belgian local division, actually the saisie applicant was a bit late in that it knew the facts at hand from June, and then it waited until September to apply for an order, and the court stressed that point, saying it doesn't help that you waited so long. But in the end, it didn't punish the applicant. So it didn't apply a very strict or stringent view in that you should have acted quickly, which is a bit similar to saying you should have provided evidence in a more in a faster way, or you should have announced. So if it's any indication, we do not see the very strict approach that actually this provision rule or Article 13 could allow the UPC to follow. So I thought that was interesting as well. And also, I fully agree with the relevance of Rule 171.2, which says if there isn't any specific challenge on a piece of information or fact, the court can accept that as true between the parties. And I just wanted to share maybe a different perspective that can be used to look at and understand this provision, is that you can also look at it from a right to a fair trial perspective, because as you know, in several legal systems, you know, if a court wants to use a specific information that hasn't been discussed between the parties, it must provide the parties with the opportunity to discuss it beforehand. That's part of a right to a fair trial. So maybe in a very fast-tracked system as the UPC, where you don't have much time for such back and forth, this can be seen as an interesting blanket statement that says, well, you know, parties, this is a prior warning that anything that you're not going to discuss, we can use it, meaning the court, we can use it and held it as true. Maybe you can look at it from this perspective, and that explains how maybe to interpret this provision. So I just wanted to share those two brief comments beforehand. And since I'm the last one to speak on this topic, I will be maybe a bit more brief than my colleagues. Actually, for the French part, the burden of proof is quite similar to what is provided in Article 54 of the UPC agreement. You know, the basic principle is that a party alleging a claim must prove it. That doesn't change in France, of course. Courts sometimes accept as true statements that are not challenged. This is not applied very consistently, but that happens. And also we see maybe in the opposite direction, courts do use or do take the initiative of raising issues that were not specifically discussed between the parties. But again, as I was saying, in most cases, it gives the parties the opportunity to comment beforehand, either in written pleadings or most often during the final oral argument hearing. So, you know, the basic principles are there. If we want to look at it in a more precise manner, I can provide a brief description of what is included in France in the first equivalent to the statement of claim, which is the summons and the merits. They usually contain a brief description of the case, technical field, and patent claims. First description or demonstration of the infringement based on the evidence that is available at the time, depending on whether or not a SASI has been formed. And also, of course, you shall indicate the measures that you request. But in contrast, you do not have to provide any arguments in relation to patent validity, except, of course, in PI cases. So all in all, a fairly detailed and strict, I mean, not strict, but complete, right, comprehensive obligation to provide a number of elements in your first summons. Quite similar to what we see in the list of Article 13, actually. So no deviation here. One interesting aspect to maybe keep in mind is that increasingly Paris Court has indicated that it doesn't see any late prior art being raised, you know, after 2, 3, or 4 exchanges of pleadings. It has increasingly indicated that this is going to be sanctioned in the future, and maybe some late prior art could be even set aside if the court considers that the party has used, you know, has made use of the proceedings in a not very loyal way. So there's a link here to the requirement of Rule 13 in particular, and how all of this will be assessed before the UPC. Is that increasingly so? I think that parties are going to be expected to be diligent in their evidence producing attitudes, especially since the UPC is so fast-tracked. Yeah, so that's the French way of doing, which is quite I would say, quite similar to the UPC, and we can expect, French UPC decisions and case law to not deviate from that, in my.
Thank you very much for your detailed explanation and your thoughts on Rule 13. We have already seen the first decision of the Court of Appeal. The Court of Appeal had in its decision to answer whether a statement of claim has to serve as annexes or whether it is sufficient to upload the annexes and evidence at a later date. I think, Carl, you want to go more in detail?
Yes, thank you very much, Carsten. I just saw that there's a question from the audience. I think it relates to the saisie and inspection, and therefore I would say we put it to the end of the presentation because we will come to the saisie and inspection. So having said that, as a basic summary from what we just heard, I would say that the German perspective is the one perspective giving the least importance to evidence, because in Germany, I think I left out this final statement in the presentation before, but in Germany it's really about the statements of facts in the first place, and it's not about what can be proven by means of evidence in court, but rather how evidence are established by statements of facts. And very interestingly, I would say this is reflected in this first Court of Appeal decision, which originally comes from the local division in Munich, in which so generally the decisions dealt with the question of how to determine the period for filing the statement of defense. And in the case, the plaintiff has filed the statement of claim without providing the evidence that have been indicated in the complaint. So the exhibits were filed at a later stage, and the local division in Munich said that the period for filing the statement of defense is calculated by reference to the date stamp of the statement of claim, and there's no it is not a reasoned request to ask for an extension, because yes, and now I would say from the German perspective, the evidence is not that relevant. It really is about what is in the complaint. It's really about the statement of facts, and the Court of Appeal did revoke this decision. They said, okay, it's true that the period starts once the statement of claim has been served, but it, as a general rule, it constitutes a sufficient and reasoned request to ask for the defendant to ask for an extension if the evidence is filed later, and you can, as a general rule, you go for the full time between filing of the complaint and filing of the evidence, which should be added in order to meet the requirements. Saying actually that it is about evidence, it is about what can be shown, what can be proven in court. So this may be a minor indication of this different perspective, right? And I think, Colin, you found another very interesting decision.
That's correct. Thank you, Carl. Maybe if we move on to the next slide, please. Karsten.
Yes.
Sorry.
Okay. Here.
Awesome. Yes. Thank you. Actually, so that's right. That's correct. This is the well-known now My-Stromer decision that probably a number of you have already seen and reviewed, which was granted, which was the first ex parte PI grant before the UPC, which was issued by the Düsseldorf local division back in June. and we've all seen and read about this from a PI perspective. What's interesting is that it also contains very relevant comments for evidence, and I will briefly comment those as follows. Is that so a PI request was made. Obviously, the court looked at the relevant right brought forward by the patentee, but also, you know, the circumstances of the case and the evidence that was put forward by the applicant. And one interesting aspect, just to, you know, just to have a first reference point as to what is considered sufficient by the UPC for a PI grant, because so far that's the only decision we have in this respect. So we have to start from here and build our understanding of the thresholds put by the UPC in this respect. So we can see that Maestromer, the applicant, provided that's how the court reports it. Of course, we don't have the access to the application, but they provided evidence related to the marketing offers for sale and deliveries of the accused product. They also provided information related to has any deliveries have taken place or not. We can maybe assume that they've conducted some maybe private investigation to determine that. So that's another example of what they've used. And also they've adduced evidence related to what was available on the defendant website in the form of an order form, which was available on such website. And so that's a first indication of what the court looked at, and that it deemed sufficient, along obviously with you know, the other elements of the application. But that's the first interesting thing to look at. And also, obviously, you've heard that, or maybe seen that the defendant had filed a protective letter because if you look at the case, there were circumstances that made them be aware that a PI request could be applied for. And so they filed a letter a bit in a rush in a few days. And so the court looked at it and said, this is not, the content of such protective letter is not sufficient, or it doesn't sufficiently rebut the argument put forward by the applicant. So, you know, that's one of the thing that the court looked at. And also it said, interestingly, that you know, in the last paragraph where it discusses content of the protective letter, it also says respondent has not significantly denied either out of court or in its protective document. So it hints that it could also, or it did, look at out of court documents such as exchanges, prior exchanges between the parties, and in this case there were a number of exchanges. So that's another angle to look at if you are in the, you know, situation of determining whether the evidence that you are intending to bring forward is sufficient or not. So
Colin, if I may interrupt here.
Yeah,
so
of course.
My impression is, so the decision is from the local division in Düsseldorf, and I would say it's rather close to how a national court in Germany would have decided the case. So it's basically about adding up what both parties said, completely relying to the factual statements of the parties, and the means of evidence, the level of evidence is rather low, which is the thing that is surprising from your side. Would you say that that you would have dealt differently with the case in France? Would you say that the level of evidence would not have been sufficient, or that you would have, for example, initiated the proceeding with a saisie? What is your perspective on that?
I don't think from an evidence point of view, the decision would have been different in France. obviously a CSE would have been a very interesting option to add to that, and the result of the CSE would have been fed into the PI application, of course. But I don't think that a CSE would necessarily be a prerequisite for a PI, and there have been some PIs granted without a prior CSE. So I think we can safely say that there's no real argument to say that in France it would have been decided differently.
Very well, thank you. I think, Carsten, we
have to
go on with the next.
We have to move on.
Next topic.
Okay.
I would have many points to address, but if I look on the clock, we have to move to our next topic, the means of evidence, and in particular, the witnesses and experts. The means of evidence are generally listed in Article 53 of the UPCA agreement. The rules of procedure differ between the means of evidence and means of obtaining evidence. Rule 170.1 of the rules of procedure sets out that the means of evidence. In Rule 172 and point 3, the means of evidence are determined. So we will look in detail on the means of evidence that are written evidence, in particular documents, written witness statements, drawings, photographs, etc., pp, expert reports, and physical objects, so in particular devices, products, embodiments, and we have the electronic files and audio and video recordings. So the means of obtaining evidence according to Rule 172 are a hearing of parties, requests for information, production of documents, summoning, hearing, and questioning of the witnesses. So that's means of evidence of obtaining evidence. So the written statement of the witness statements is a means of evidence. So that's a distinction. The appointing and receiving opinions from summoning and hearing, questioning of experts, ordering inspections of a place or a physical object, conducting comparative tests and experiments, and sworn statements in writing. And we have ordering a party or third party to produce evidence, or ordering measures to preserve evidence. That's the CZ, and we will come to that at the end of our session in detail. So there are different ways of obtaining evidence, and the court is not limited to these means of evidence. The parties therefore have many ways of gathering evidence if they do not have it all before the case starts. From a formal point of view, all evidence is of equal value under the rules. In the following, we take a closer look on the written evidence and expert reports as means of evidence. It is worth noting that written evidence is a means of evidence, and the witnesses at the oral hearing for the party are to obtain evidence, as we've seen before. However, the distinction makes sense, as I explained. So the witnesses. The evidence of witnesses is regulated in detail in the rules 175 to 180, rules of procedure. According to Rule 175, rules of procedure, the party who wants to offer a witness evidence shall lodge a written witness statement or a written summary of the evidence to be given. But it's also possible for a party to apply according to Rule 176, rules of procedure, for the hearing of a witness in person at the hearing. According to the next rule, the Rule 177 of the rules of procedure, the court can order that a witness be heard in person of its own motion, or where a written statement is challenged by the other party, or on the application for the hearing of a witness. The main rule seems to be that the written statements are submitted in writing, and that the witness, this is only questionable orally if there is reason to do so. This is to be welcomed in view of the international disputes before the UPC and the correspondingly long journeys for witnesses. Now I'm very interested in how this compares to the procedural law in Germany, Italy, and France. Karl, I think we will start with the German perspective.
Yes, thank you very much, Carsten. Yeah, of course, the means of evidence are not that much different than in the UPC agreement. But I would say again there are some notable differences, and they simply reflect what I have said before, that in my perspective, it is in Germany, it's about the facts more than about the evidence. And the UPC tends to give the evidence a little bit more of a focus here. So when it comes to the means of evidence, in Germany, we have witnesses, we have experts, we have certificates, we have a hearing of parties, and we have the inspection of objects as the basic means of evidence in the legal framework in Germany. A notable difference is one aspect that Anita has already explained earlier in her presentation, is that the very typical documentary evidence, so the documents you produce in proceedings, as well as private expert opinions and legal expert opinions, everything you produce in support of your complaint, not everything, but quite a lot of things, which would be the typical documentary evidence, are from a legal point of view in Germany not regarded to be means of evidence, but that would be rather a detailed factual statement by one of the parties. So they are simply regarded, factual statements and facts. Of course, from a psychological point of view, it is always helpful to have such documentary evidence, and it's definitely useful to rely on private expert opinions in some regards. So and they are even produced as evidence. So I would even, when I file a complaint, I would even say, okay, I refer to this evidence, although from a legal point of view, it is not evidence in Germany. But I would say that this already shows that quite a range of things that are covered as evidence under the UPC agreement is not regarded evidence in Germany. Again, is an indication that it's more about the statement of facts in Germany and less about what can be proven by actual means of evidence. And
so I have a question, Karl.
Yes,
May I
go for it.
interrupt you? It sounds like the plaintiff has more options before the UPC in terms of evidence. Is that an advantage of the UPC? So maybe I haven't got enough evidence, so it's maybe an advantage to go to the UPC and not to the national German proceedings? What you're thinking about that?
I wouldn't say necessarily that it's more options. I would say there are more means that are considered to be evidence, which you would have relied to as well in Germany. So it's pretty much the same means, but they are regarded evidence before the UPC. And I think that could also mean that there's higher requirements in order to what you need to produce before the UPC. And since on the other hand, the requirements are rather lower in Germany, I would say from my current point of view that it's also good to go to the German court. But since what you can see from the local divisions in Germany, I would say they pretty much stick to what they have done before in Germany, which is obviously it's the same for the Milan court. We come to that at a later stage, and other local divisions when it comes to the numbers of saisie decisions so far issued, of which I would say none have been issued in Germany, although there's a number of cases here. But I wanted to keep it short here. So one other aspect is that the way of introducing evidence is quite different in Germany. And you would not rely to a written statement of a witness, and you would also not rely to a written statement of the expert, but offering evidence in Germany usually only requires to name the witness and to say to which factual statement you relate and for which factual statement you want to offer evidence by naming a witness. And that's, as you can see again, that's quite different because until the oral hearing, you will only have the factual statement, and then anything can happen at the oral hearing, but you would not produce a written summary of the witness statement. The only exemption to that would be in preliminary injunction proceedings where you have only prima facie evidence, and that is you need to work with affidavits and also with written expert opinions. So
yes, as we have heard in this discussion already, and I've learned from you in our discussion yesterday, it is common in Italy and France to start with more evidence from the beginning of the proceedings in comparison to patent infringement cases in Germany. May we start with the Italian perspective?
Yes, thank you. So basically in Italy, we have the means of evidence, let's say, are either, let's say, regulated in the general civil court proceedings, but we also have a specific means for IP, let's say, proceedings, which are some of them, let's say, quite similar to the UPC, for example, the exhibition of documents, or when you request for information to the other party. The same, or what we can see, let's say, as a similarity with the German proceedings, which differs, let's say, with the UPC, is that it's not common for us. Actually, we don't have a witness written statement. This is something that normally it's done orally in Italy, and if one were, let's say, to submit written witnesses, they are not going to have a lot of probative value, let's say. I mean, unless they are submitted through, but witnesses are oral, normally taken in Italy. And as regard the experts that you mentioned, okay, this is something also that we do it written. I mean, one thing is when you as a party, you want to have your technical expert relation. So this is something that you are going to submit in written. There could be a request for clarification, but often, let's say, this comes in written. But this is something separate, let's say, from what is the technical expert that is appointed by the court. That I think that's what you mentioned. This is not, technically speaking, let's say, a mean of evidence, neither in Italy, which it seems to be before the UPC.
Yeah, I would just add to the grower presentation of Magali that, as I said before, judges in Italy are not technical nor are trained to be technical. So in patent cases, it's very common that they rely on a court-appointed expert to carry out a report in order to assess the validity of the patent and the infringement, because as this is a major big difference between the German and the Italian proceedings, is that you can challenge the validity as a counterclaim in proceedings as far as you can assess also the infringement of the same patents. So we don't have the bifurcation, which is well known to our German fellows. So what I was saying is that this is not actually a proper means of evidence, because it's an auxiliary to the decision of the judge to rely on a court-appointed expert. This is usually a typical phase in patent proceedings in which, as I said, the court-appointed expert will discuss with the two experts appointed by both parties in relation to the claims and to a question that is posed by the judge to the court-appointed expert. And basically, he has to decide whether the patent is valid and then whether the pilot has been infringed by opposite party products. As I said, this is not a typical means of evidence, which is could be, I mean, not let's say not requested by the party can invite the judge to introduce, but it's not an evidence, a proper evidence. It's such a phase in which the court-appointed expert will decide. And just to link with what Colin was saying before in relation to the gathering evidence here and the timing of providing evidence, it's quite strange in Italian system is that since we have to provide all the evidence at the beginning of the proceedings, either in urgent and also in proceedings on the merit, in this kind of a technical phase where there is a court-appointed expert, he also can gather the prior art documents without the parties has already filed it before. So this is something which is atypical for our proceedings, but this is something which is very important, because sometimes when you are filing all the prior art to challenge the validity of a patent, you can also miss something that the court-appointed expert can include further on in this phase of evidence. So in replying to Colin, is that in Italy we have this kind of strange phase in which all the prior art search and all the documents can get into without the burden of proof, as we said before. This is something which is very, very typical in Italian proceedings. Usually witnesses, means of evidence, which is a typical means of evidence, they are heard orally during the proceedings. However, witnesses are mainly related not to assess the technical aspect, as I said, validity and infringement, but mainly, for example, they are assessed to, let's say, compensation for damages and the amount of damages that have been produced. So it's more typical to other kind of claims instead of infringement and validity.
Colin, I think we can go to the French perspective.
Thank you, Karsten. Just one comment on what was already shared in respect of the wide range of means of evidence that are available for the UPC. And your question, Karsten, is this an asset or an advantage or not? I get your point, you know, meaning that with great powers come great responsibilities, and that maybe if there's such a wide list of means, maybe it hints that the parties are to use them, and maybe the court will sanction parties that are a bit negligent on this front. I would be more on the side that the UPC was designed as a patent-friendly court, right? And so I view this list more as a way to make that possible, giving the patentees the greatest number of options, and not that much the beginning of a threshold that would say you have to have at least 4 or 5 in this bullet point list. But of course, we'll see how this plays out. But this is my personal take on that. I think we're in a patent-friendly system, and the goal is to give patentees the most number of options. So moving on to the French perspective, I'll be very, very quick. As a number of you know, the gold standard in France is really what's publicly available, both in online or physical purchases. And when I say publicly, I mean even after you get a saisie order, but what you can get both from the public side of things and the saisie contrefaçon. And the saisie contrefaçon, as you all know, is a very powerful tool used here, maybe in more than 80 or maybe 85% of cases. The other means of evidence that are referenced in the UPC system are less used in France, and starting with witness statements, or even less so with the hearing of witnesses. This almost never happens. Of course, I think that French practitioners most of them will view the possibilities afforded by the UPC as a good thing, and will probably try to incorporate the hearing of witnesses and use witness statements more. So I think we will move towards this direction given by the UPC rather than the other way around, at least in France. So yeah, witness statements are not used a lot. Private, technical, or legal expert reports are used when they are necessary in complex cases, whether it be complex on the technical side, or where there are legal aspects that are very seriously challenged between the parties and that require to have opinions from, for instance, law professors and the like. And last but not least, forced production of evidence. It is very rarely used because there's such a high threshold to be met that it's very rarely decided by courts. You have to specify in your request which documents specifically you want the court to force the other party to adduce. You have to say what it is, what it contains. You have to be very specific. You have to know all of that in advance, which makes it quite hard in some instances. So yeah, so basically all those means of evidence are less used in France. And as I said, witness examination is never used. So to loop back on what I was saying, the French way of doing things is a lot of saisie and a lot of bailiff reports, but I think before the French, UPC courts, I think attorneys are going to use the other means of evidence as much as they can to try to improve the way they support their claims.
Yes, thank you very much for your insights in the French procedural law. Yes, from my point of view, it's so the many opportunities show that the rules were influenced by the different national systems, and every member state puts in what kind of options in that member state, in that national procedural law is the best practice. So you have all the opportunities in the UPC. So we will continue with the saisie and inspection, which Colin has already mentioned. The saisie is in order to preserve evidence. For the German that's not very familiar with the saisie. According to the rule 192, the application is possible before and after the start of the main proceedings on the merits. In each case, the application has to fulfill the requirements of Rule 132, which we would not look like in detail. So if the application for preserving evidence is lodged where the main proceedings of the merits of the case have not yet been started before the court, the application shall, in addition to the basic requirements, contain a concise description of the action which will be started before the court, including an indication of facts and evidence which may be relied on in support. According to Rule 194, the court has many opportunities to organize the proceedings and to examine the application. The court shall have the discretion to inform the defendant and invite him to lodge an objection, summon the applicant before or both parties to an oral hearing, or decide on the application without having heard the defendant that's in case of urgency and the risk of evidence being destroyed, the court can order, among other things, that search measures are performed by a person specifically designed by the designated by the order. The court can order also that the order is immediately enforceable, and the seized elements can only be used in the proceeding on the merits of the case. For the protection of confidential information, the court may order that the information to be disclosed only to certain named persons. The appeal is within 2 months admissible if the court ordered measures to preserve evidence without the defendant having been heard. The defendant may request a review of the order to preserve evidence within 30 days. So that are really the rough points. We will look in the following on the first CZ decisions. A quick look on the inspection. The inspection is ruled in Rule 199 of the Rules of Procedure. The court may, on a reasoned request by a party, order inspection of products, devices, methods, premises, or local situations. For the protection of confidential information, the court may order that any of the above be disclosed only to a certain named persons and subject to appointment, appropriate terms of non-disclosure in accordance with Article 58 of the agreement. So the rules of the CZ apply mutatis mutandis, so that we do not need to discuss the rules again in regard to the inspection. Colin, the CZ comes from France. Is the CZ of the UPC the same as the CZ in France? Can you tell us more about the differences and the similarities of the CZ in the rules of procedure and the CZ in France?
Of course, it would be my pleasure, Carsten. So actually, yeah, the UPC procedure is very closely inspired by the French CZ contrefaçon seizure. We can see 2 main differences for me. The first one is that in France, CZs are always ordered ex parte, meaning without the defendant being heard or even informed of the application or even the order. In the UPC, not only is there a possibility for the defendant to be heard in some cases, but even further than that, the principle is that the CZ is not ordered ex parte, and it's only in cases of urgency or if there is a risk that evidence might be destroyed that the court could or can order the CZ ex parte if it's duly justified by the applicant. So it's a very important difference. So far, we've seen CZ is being ordered ex parte under the UPC, but this may not always be the case. And as I said, the principle before the UPC is not an ex parte system. The second main difference is that as a principle before the UPC, the technical report or report, call it as you want, that is going to be drafted by the bailiff or technical expert that is going to perform the CZ is to be, as a principle, provided to the UPC court. And if the UPC deems it appropriate, it can also be provided either straight away or after a certain point in time to other persons involved in the proceedings. In the CZs that have been ordered by local divisions of the UPC, we've already seen that the local divisions have used this possibility of providing the report to other entities than the court, and in this particular instance, to attorneys of the applicant. So those are the 2 main differences in my view. So if we move back to the French regime, is this, Carsten, is this the first French slide, or is there one before that? I think there's one previous slide about the CESI, right? Thank you. So as I was saying, CESI is really the gold standard for evidence in France. It's performed in approximately 90% of cases. It is a right of the patentee in a very different fashion than the UPC. That's why it's really always heard ex parte. There isn't any prima facie evidence or urgency requirement. You only have to provide evidence that you have a patent that is in force, and you must provide a reasonable amount of evidence that makes it likely that your patent might be infringed, that you are entitled to search for information in this respect. But this is a very low threshold. There are few instances where a CESI request is denied. And most of the cases when it is denied, it is because the measures that are requested are too broad, and the judge deems it too broad and wants the applicant to submit a new request that is narrower. But it isn't, most of the time it isn't, because it considers that the applicant hasn't put forward sufficient amount of evidence of likelihood of infringement. The threshold is very low. So it is, as I said, always ordered ex parte. The defendant can never be heard. It can be, like in the UPC, applied for both before and after the start of proceedings on the merits. Obviously, because there is such an element of surprise to the CESI, it is in most cases applied for before proceedings on the merits are initiated. And then the rest of it is very similar to the UPC CESI. The order is immediately enforceable. The CESI must be carried out in a specific amount of time that the court will set. It can be carried out pretty much everywhere in public places, such as trade fairs, which are a very popular forum for CESIs, because defendants are showing their products sometimes for the first time, and sometimes this is the only place where you can reach some defendants from foreign jurisdictions. This is a very popular forum. It can also, and very interestingly so, be carried out in private premises, such as headquarters or an industrial plant or a lab sometimes. It can also sometimes be carried out at a third party, which holds information related to infringement by the ultimate defendant. So a very wide area of possibilities for the location of the CESI. Of course, simultaneous CESIs are possible. We've seen sometimes 3, 4, 5 CESIs being carried out at the same time on the same day to ensure that the element of surprise is preserved. So that is completely possible on the condition that you justify, of course, before the judge, that you need such a disruptive act in order to safeguard any relevant piece of evidence that you want to use in proceedings. It is performed by a team usually of 3 bodies of people. Sometimes you have 2 from each category, but essentially 3 categories of professionals: a bailiff, patent attorney, and IT expert. So that's the basic CESI team. And I expect for the UPC CESIs, it will be quite similar, because you usually need those professionals to cover the whole breadth of professional capacities that are needed to perform a CESI. And it can last up to a few hours, up to sometimes 2 or 3 days in a row in cases of very large CESIs. Moving on to the next slide, and in a very similar fashion to the UPC, the bailiff report is usually available to both parties within 2-3 days. I was talking about the timing aspect. Of course, as we said before, the UPC, the principle is that it is only provided to the court and upon a specific decision by the court to other parties. In France, that's a bit different. It is provided to both parties right away. The only exception to that is that sometimes some elements are placed under provisional seals, most of the time because the seized party alleges that they contain trade secrets. And in that case, we have instances where the bailiff report is provided either in full, but it's provided in a redacted way, or sometimes you leave the opportunity to the adverse counsel to review it before providing the bailiff report to your client. Sometimes that happens. And then, of course, proceedings on the merits must be initiated within 31 days. Otherwise, the bailiff report in the saisie on whole is null and void. And the defendant can challenge the saisie after it has been performed on three main grounds. First one, on the scope of the saisie that was authorized. It can put forward information that the applicant didn't provide to the judge, and that could have changed its ruling, such as, for instance, the existence of an opposition proceedings on the patent at stake. It can also challenge the saisie on the grounds that it was performed not in accordance to the order, and of course, it can challenge the way the elements were seized. And if elements were placed under temporary seals, it can ask the court to decide that they must be returned to the seized party if they are not relevant to the case. So all in all, if you know the French saisie, you know most about the UPC saisie, and now you all do. But yeah, the two main differences is the hearing of the defendant.
Yes.
Yeah, and the report.
Thank you very much, Colin. I think that was very good to have this very detailed overview on the French saisie, because the saisie is very, as you said, closely related to the French saisie, the UPC saisie. We need to keep the time a little bit in mind. Therefore, and we still have one question, and we have some interesting decisions to discuss. Therefore, Alessandro, can you give us a very brief overview on what is different from the Italian perspective to the means Colin has just discussed, and then you can directly jump into the decision of the Milan local division, I think.
Yeah, okay. Thanks, Carl, and thanks, Colin. Actually, in Italy, we have a pretty similar system in a sense that the CZ can be ex parte and also can be actually a means of evidence, which is actually applied in the, let's say, 80–90% of cases, roughly, also in Italy. The main distinction in the CZ, as we would see in the first case of the UPC Local Court of Milan, is that we have usually a distinction between description order and seizure of products, because this is important in order to also assess the scope of protection and the burden of proof, which is under the plaintiff. Because when you are requesting a description order, the description order usually is related to something that you want to gather in copy. For example, technical elements relating to documents, programs, catalog, or either the description order can cover accounting books in copy, or orders, or invoices, etc. The seizure itself is something that you can request together with the description order, and the seizure actually is something that you are carrying out, bringing the product out of the possession of the defendant. This means that the defendant has not the possibility to use the product which is seized as itself. So this means that description order and the seizure are elements to preserving evidence in both cases. In one case, the description order can have also a broader scope, in a sense to have also accounting books and commercial documents to be gathering copy, but seizure itself is something that you are taking out of the possession, for example, taking out of the market the infringing goods of the defendants. This means that for description order, as Colin said, in Italy we have not a high degree of evidence to be provided, since that still you have to provide a kind of prima facie of evidence of violation of the patent, and still the patent has been considered valid. So usually we file with the description order request a report from a technical expert appointed by the party in order to convince the judge that the patent is valid and also the patent has been infringed or is likely to be infringed by the opposing party. This means that the party has not still the evidence of the violation of the infringement, and through the description order is gathering the evidence to be used under the proceedings on the merits. A different discussion has to be made on the seizure of products. The seizure of products is still a means of evidence in the sense that you are preserving a product from the other party's possession in order to be used in a proceedings on the merits. But in this case, you still have the chance to gather other evidence on the market. For example, buying the product, a sample of the products on the market, and assessing that is violating your patent. This means that you are on higher burden of proof in order to convince the judge that this is something which is clearly in violation of your patent.
So,
if I may, sorry.
Yeah.
No, if I may add something, if in my understanding from what you mentioned, Colin, maybe the difference that I can see between, you know, the Italian and the French approach is that in your case, you don't need to prove, if I understood, the periculum in mora, and in Italy, let's say the description or the preservation of evidence is very unlikely, let's say, to be given if there is another way to obtain that proof, because what you want to obtain with this is, you know, obtain like those means of proof that you know that they're there, but you cannot obtain it otherwise. For example, how this works, the machine, or maybe the machine is very expensive or it's not circulating in the market. Because if it is something that you can, I mean, it's broadly in the market, it's very unlikely, and you understand, let's say, how it works, it's very unlikely to be given. And in my understanding, the French approach is a little different in that sense compared to the and maybe just to add on top of what Alessandro said, that yeah, I mean, the description in Italy and the seizure are very similar in some functions, but on top, let's say, maybe what you can, you know, the extra element that you can obtain with the seizure is that you let's say, from the availability of the infringing party. So in that sense, it could be a little yeah, an extra yeah, it has an extra element, let's say, of benefit in that sense. Yeah.
Yeah, as I said, the requirement, just to quickly close on that, Carla,
Yeah.
we can go. The requirements for either the description order or the seizure are first, prima facie evidence and validity of the patent and infringement, and secondly, the urgency of delay. So this brings us to the slide that the Carsten put on. It was the first case. In the sense that the idea of the description order and the seizure is that you cannot wait for the proceedings on the merit to obtain a decision. Since while you're waiting, the object, the product, the infringing product can be destroyed, can be sold, can be unbalanced, and etc. So this means that you need to act quickly, and you need to act without the other party is being informed. This is why usually description order are granted ex parte, as Colin said, but seizure usually are not granted ex parte. I mean, it's not likely that will be granted ex parte, because they means that they have another degree. No,
so we have seen that there are 3 decisions from the Italian local divisions on the CESI, and none in Germany so far. So I think this is remarkable information already. So it seems that each jurisdiction is kind of continuing what they are used to, and the local divisions are going with that. Is there something that was surprising for you, Alessandro, in the first UPC CESIs compared to the Italian system?
Yeah, it was surprising, as we discussed in the last days, unless my Italian attorney perspective could be, destroyed by your perspective. For you, this aspect that it was surprising for me, it's not for Colin and for you. However, let's say that, yeah, the first UPC case law in relation to the first CZ was in relation to a textile machinery was exhibited during a fair in Milan. It was this big fair. It was lasting, I think it was 6 days, 5 days, no more, which this infringing machinery, the big infringing machinery, was exhibited by the defendant. And the applicant, as I said, was filing a description order, let's say description order for us, because I mean, we are more used to that, in which they filed, as I said, a technical opinion by the applicant patent attorney, in which there was assessment of validity of the patent and infringement on the patent itself, and the request for urgency. For example, let's say the fair was lasting 5 days. This is why it was also a foreign company. I think it was Turkish, or yeah, it was Turkish company. So this is why the urgency to be granted this description order has been assessed. And then it was also granted ex parte without the other party was being informed, because, as we said, the seizure can be also assessed after the hearing in which the other party is informed. In this case, usually differently was what Colin was saying in France, and this is actually connected to what I was saying at the beginning. Since the judges are not technical judges, they always appoint a court party expert in order to carry out the seizure or all the technical activities. So also in this case, Mrs. Zana, which was the judge of the local division, appointed an expert who was also requested to draft a report after the raid that was carried out during the fair. Going back to the things that was surprising for me is that the judge authorized to have access to the files gathered and the evidence gathered during the raids in the description order only to the 2 plaintiff attorneys and also to 1 expert. In my experience, which is actually relating to 30-40 seizure and ex parte orders, description order per year, in the last 10 years, is that during these raids, the plaintiffs usually has no access to all what is doing the court-appointed expert. Since there is a court-appointed expert, the plaintiff, has no information in relation to what is actually being gathered. usually are gather a lot of documents and also a lot of means of evidence, which are not accessible to actually to both parties, because usually the judges are considering privileged information, privileged and confidential information until the hearing, which is scheduled the beginning order is taken. So this is why it was surprisingly for me, because usually no one has access to the elements that have been gathered during the race.
I mean, I would say from the German perspective, so we agreed before that the order is quite in line with what we would do in Germany in a similar proceeding, and but my interpretation is that there is not, so you do not have access to the full process, but the access for the attorneys as only access is only meant to be for the time of the inspection in situ at the place of where the inspection takes place, and on the process afterwards, the expert will analyze everything and make an expert opinion, and then the attorneys will have access to that expert opinion, but not they will not look over the shoulder of the expert during the whole process.
Yeah, but also, for example, just put yourself in a position where you are raiding opposing party premises. For example, a warehouse, not just a fair, a booth in the fair, but let's say a warehouse.
So the attorneys would not have access to that in the Italian.
Yeah, I mean, even though you have a lot of documents there, even though you are there just trying to see. And also, it's important to say that the defendant, in this case, as Mrs. Zana said, we don't know how the defendants can be informed about the evidence that has been gathered by the plaintiff during the raid that will be used during the proceedings on the merits. This is actually, for us, a kind of a breach of the right of defense, in the sense that the defendant has no right to see, appears to have no right to see and to defend itself at the hearing itself.
Right. I think we are already about 10 minutes due, and there's still some one question open. So the member of the audience asked, with regard to the proceeding and the issue that the enforcement is governed by a national law, how you would take this into account in the application itself, and whether you would make separate applications for different member states in order to take that into account. So I just wanted to address that question briefly. I would say from my perspective, but I'm probably the one having at least to do with saisie orders so far. I would say that you usually need to say in the application where this saisie is going to take place, and that already makes it necessary to have different applications, or at least consider different places where the application should be enforced, and therefore gives you the chance to align what you are asking for with the specific member state in which you want to enforce the application. And I understood that, Colin, you said there are several situations. You have about 7 or 8 applications at the same time in order to have this moment of surprise. Maybe you can further address this question on how you would deal with that.
Absolutely, yeah. And without daring to provide legal advice, in this webinar, but my take on this is that I think it could be seen, there would be a risk of a court, a UPC court, a local division, finding that you haven't been you haven't complied with the necessity of loyalty if you do not inform the court of a separate CESI application that you would have submitted to a different, a different local division or to the same division but separately. So in any case, the court is going to have to be informed of any and all applications that you submit in respect of the same or related parties. So I think it would be preferable maybe to use the same application, but as rightfully mentioned in the question, anticipate and specify for each territory on which the CESI is to be performed, the specifics of that and by whom and how the CESI is to be performed. So I would rather maybe use one application, but have different sections in which you would say, well, in Belgium it's going to be performed this way, in France this other way, so that the court has all elements in front of it and can basically take what you've written in its order and use it as such.
Thank you very much, Colin. I think
Okay.
we need to skip. Yes, I think we need to skip the German perspective. I just want to add one aspect. It was meant to be the shortest part to say what the German CESI is, but because it's really rarely performed in Germany, it's no need to look into that into detail. But we see it's in less than, I would say, in my practical experience, without having a detailed statistic on that, it's less than 10 and even less, probably even less than 5% of the cases in which you would perform a CESI in Germany or inspection order. And we don't even have a detailed regulation for that. So it was very interesting to see these differences, and also that these differences are applied before the local divisions, seeing that although there's a number of cases in Germany, there is no CESI so far, no CESI decision, as far as I'm informed, and several CESI decisions in Italy.
And
I
also
think
identically surprising that there isn't a French CESI decision. Right. It will come.
Yes, thank you very much. It was very interesting with all of you, and to get your insights. And I will now hand over to Niklas.
Okay, thank you guys. Thank you, Magali, Carsten, Carl Alexander, Alessandro, and Colin. We have already addressed the one question that we had, and given the time, I won't ask any further questions to all of you, although there are a lot of open aspects that we could address, and hopefully we can continue this discussion sometime soon. So this not only brings us to the end of this session, but to the end of the webinar as a whole. And I would like to extend a big thank you to all of our speakers for putting in the effort, and also for all of you participating and making the time and listening in. And if you cannot wait for the next AIPPI event to happen, then fear not, and keep some space in your calendar, as the AIPPI spring meeting is already coming up, and you should see a slide advertising for it right now. Finally, let me say, if you are a young member of AIPPI yourself and interested in becoming part of our German international young member community, please feel free to reach out to me or any other member of the Young Member Advisory Committee to the AIPPI, or any other young member you may know. There is a contact email address for that on the AIPPI homepage, but you could also just simply contact me or anyone else, for example, over LinkedIn. And we would be happy to have you participate as well. That being said, thank you again for attending our webinar, and I wish all of you, and particularly our speakers who have done such a great job today, a wonderful and great rest of the day.